Talk Shoes. Recorded live.
Hi, everybody. It's Thursday, December 16th. It's Thursday night, and tonight we have Gene Keating back on to answer some questions that you might have after his Tuesday class. All of you that participate in it, I know you probably have questions. So, hi, Gene.
How you doing?
Fine, thank you. I'm getting feedback though, so I'm gonna need Widerspiel, can you press *6?
Sure.
Thanks. Okay, how's that? I think that was it. Okay, great. So where do you want to start, Gene?
Well, get some questions.
Okay. First, we've got North and West Colorado. That's Nancy. Go ahead, Nancy.
Yeah, that's Nancy. Can I ask a question that wasn't specifically on last night? It's about what you talked about when you were on before. How do you charge the account, and how exactly do you write the money order? Because I've had no success.
You write, what you do is you convert the bill to a check.
Yeah.
You know how to write a check?
Yes.
Okay, that's exactly how you do it. You write pay to the order of United States Department of Treasury, Timothy Gunther, Governor of the International Monetary Fund. And then you charge the sum said to whoever sent you the bill.
So it could be IRS or whatever.
Doesn't matter who it is.
Okay.
Gas company, electric company.
Okay.
Tuesday night, I'm going to go into all that. I'm going to show you how to do it.
Wonderful.
On a visual. I'm going to do a visual. Show you the documents, how they're filled out.
And then who signs this?
You do it. You got to sign it in red ink. If you sign it in blue ink, they're going to completely, that's why you guys are nuts. Because only a dead person signs documents in blue ink.
Okay, but you sign it as the straw man or as an authorized representative, or?
No, just sign your name. You don't have to. How do you sign your checks?
I sign with a capital first name and.
You can put authorized representative because it says that on the line that you're the authorized representative.
On what? Not on the coupon.
It says it on it. You know the line where you
sign?
On
a check, you mean?
The front of the check, where the line where you sign your signature as the drawer and the maker?
Yeah.
It says on there, if you blow up the line, it says there, authorized representative.
Okay.
It already says that.
Right.
Yeah, it's microprint.
Microprint.
Right. Now, you don't sign the back like some people have. I mean, you don't endorse it.
The reason you're the authorized representative because the account is in the name of your legal estate, which is what the all-capital letter name is. The all-capital letter name is not a straw man. It's a legal estate.
Okay.
Do you endorse the back of it, Gene? That's
why every time you go into court, they're probating. You know where the word probate came from? It came from the ecclesiastical. You know what ecclesiastic means? It means to bring a claim. That's why you guys are not getting anywhere in court. You're not bringing a counterclaim.
Well, I'd like to not get there, and I'd like to pay off the IRS.
Well, all you got to do is take their bill, anything with an amount on it if it's a bill, in ecclesiastical law, it's called a bull. That's where the word bill came from.
I thought that was a pronouncement, like a papal bull.
Papal bull. That's what it was called originally.
Okay, but the coupons don't have an amount on them. There's an amount maybe in a letter part.
Okay, when you mean with the IRS?
Yeah.
Well, if there's a coupon attached to it, you can do it on the coupon.
Yeah, and put in the amount yourself.
Yeah, pay to the order of and put the amount in there. Just like you do on a check.
Now, do you do this on a diagonal or just like a check?
Yeah, just like it is on a check. Pay to the order up.
Okay.
Yeah, come on, Nancy. You know this already.
Well, I've tried this so many times, and I just saw one that was on the diagonal. And I thought that was endorsed on the back. And I thought Gene said something about mentioning the charging to who? No, charge some certain to whoever. But I thought you were talking about charging your account or doing something with the account in there somewhere.
You credit the memory of your account.
That's it. Okay.
That comes after you charge the sum said to whoever the agent is that sent you the bill.
Right, and then said credit the account.
Credit the memory of your account and put the account number, which is your social.
Okay. Okay, great. Thank you.
And there's no endorsing the back of it, right, Gene?
Yeah, then you got to fill out a 1096, a 1040V. You got to fill out a 1040V, a 1096, a 1040, and a 1099 OID.
So you have to do a tax. But what if this is a bill that the tax return's already been done? You wouldn't do another 1040.
Yeah, you would.
You would?
Yeah, because you're reporting as income.
You're reporting the check
Let me
you sent.
what's going on. When somebody sends you a bill, I don't care who it is or what it's for. Any bill. Do you know what I mean by any bill? I don't care if it's a utility company, electric company, gas company, sewer company, trash company, city, IRS. What they're doing is the bill represents the amount of your credit that they're using. And the reason is because they're debtors in possession under a Chapter 11 bankruptcy, reorganization, and they're acting as trustees to the bankrupt estate. They're bankrupt. They don't have any money. So how can they, if they're bankrupt, how can they demand money from you? How do you owe them money if they're bankrupt?
You can't.
Can you answer that?
Oh, hold on a second. I muted her. Sorry. Go ahead, Nancy.
Nancy? She hang up?
Oh, okay. Now I'm unmuted. Okay, yes.
Okay, if they're in a declared bankruptcy, how can you own that? How can they loan you money to become a creditor? How can anybody on the private side be a creditor if they're all bankrupt? Just give me an answer to that question.
They can't.
Okay, there's your answer. Well, if they're not a creditor, what's going on?
They're trying to make you the debtor and them the creditor.
They're acting as a debtor.
But they're trying to get you to pay it.
Well, that's because people don't understand what's going on.
Right.
They're not sending you a bill, they're sending you a tax bill.
Right.
And the tax is the amount of credit that they're using of yours. That's why you've got to file a return and return it back to the IRS. The reason the IRS has got a lien on you is they're trying to see if you know what they're doing.
Okay, if I filed a return, then they say you owe X amount of money. Pay this amount.
Well, then put the amount on take the bill and do a pay to the order amount. Use a 1040V. Do a 1040V, a 1096, a 1040, and a 1099 OID. I'll show you Tuesday night how to fill it out.
Okay, great. Thank you very much.
Okay, good. All righty, we're going to move on. We've got Joanna. Go ahead, Joanna. Did you have a question for Gene Keating? Joanna?
If she's not there, can I talk?
No, you got to hold on. I've got a whole line of people. Press *8 to get in line.
Thank you.
Thank you. Joanna, hello. Okay, we're going to move on then. Let's go to, let's see. Trying to, okay. New York? Go ahead, New York. Maybe you need to unmute your phone. New York, go ahead. Okay, we're going to move on then.
Can you hear me, Gene?
Yeah, go ahead.
Yes, Gene. Gene, the IRS is levying, garnishing my pension. What can I do about that?
Because you haven't filed a return, then they can't balance their books until you do.
Mm-hmm. You haven't filed a return. You do. Mm-hmm.
We're getting a lot of feedback. If you've got your speakers on in the background, that isn't going to work. A lot of feedback. Good grief. Huh? Okay. Moving on. New York, go ahead. Did you want to say something, New York?
Oh, yeah, I was asking Gene that the IRS is levying my pension. What can I do?
Take whichever piece of paper has the lien on it, the amount that you owe.
Okay, yeah, they sent me the paperwork on levy says I owe my X amount of dollars.
What you need to do is I'm going to show everybody Tuesday night how to fill out these forms. I can't do it here because there's no visual.
Yeah, you mean the 1040, the 1096, the 1040B, and the 1099 OID.
Yeah, I'll show you how to fill it out.
Mm-hmm.
Got sample forms, how to fill it out.
Okay.
I'm going to give everybody a copy of it.
All right, yeah, I'm going to be on Tuesday's call, so I'm looking forward to it.
Okay, if you look at the forms,
Mm-hmm.
and if you got any questions, that's the time to ask them.
Okay, where can I pick up these forms now? Can I pick them up anywhere?
Yeah, go up on the IRS website.
Okay.
The 2010 1040Bs are out now, I understand.
Mm-hmm.
They come out with a that's a payment voucher.
Mm-hmm.
What the IRS is doing is they're acting as a public accountant.
Mm-hmm.
And they're balancing your books. They're bookkeepers.
Okay.
They can't balance your books. It's like when you write a check, don't you record the amount that you wrote?
Yes.
So that
Correct.
you don't overwrite?
Mm-hmm.
You don't draw on more than you have in your account?
Right, right.
Well, every time somebody sends you a bill, they're using your credit because they're all bankrupt.
Mm-hmm.
Do you know what I mean by all?
Yes, everyone is bankrupt.
Everybody on the public side is bankrupt.
Mm-hmm.
So how can they be a creditor and how can you owe them money?
There's no way. There's no way
so what's really going on?
They're ripping us off. That's what's going on.
Well, that's because people don't want any responsibility.
Uh-huh.
When you find it, if you listen to what I'm telling you, doesn't that make sense?
Yes. Mm-hmm.
Okay, so when you file the tax return, you're making a return. A return of what?
Huh?
You're returning the income, which represents the amount of credit that the person that billed you is using.
Mm-hmm.
Okay, when you return that back to the IRS can credit that to your account and issue a refund.
Mm-hmm.
And what people do is they write out another check.
That's how much of your credit that they used.
Yeah, and what you're doing is people write out another check. They give them a check plus the amount of the credit they're using. You're paying them twice. That's why they love you so much.
Mm-hmm. Okay. What about the money that they've already taken? Can I recoup that?
Yes?
Dave, and Dave said,
So you how to do that?
not really sure. And he says, he says there's some groups.
So that's another process that we have to do. That I'm going to have to do then. Okay.
That's why you're not winning these mortgage cases in court. You're not doing a recoupment.
Mm-hmm. All right. Thanks.
If you read 3305 of the Uniform Commercial Code, it says you have a right to recoupment. Recoupment is a defense or a claim.
Mm-hmm.
If you look up the word recoupment, it means counterclaim.
Mm-hmm.
And if you read Rule 13, counterclaims come in two forms, mandatory and permissive. And it says if you read 3-305, it says if your claim arises from the same transaction and occurrence as the plaintiff's claim, you have a claim. That's mandatory. It says that in Rule 13. It's mandatory. It's also mandatory in 3-305 because it arises from the same transaction and occurrence as the plaintiff's claim. Plus, you have under 3-306, you have a right to the proceeds and a possessionary right, property right, in the instrument. That means the amount of the note. The note is an instrument or a security. And you have a right to the proceeds from that, but you're not making a claim.
Mm-hmm.
That's why they when they do a foreclosure, they issue a 1099-A. So since it's a security, you have an Article 8 claim, which is an adverse claim. And the claim is under 8-102 and 8-105, 8-505 through 8-508. That's why I went into the uniform commercial. You got to understand commercial law before you start doing all this letter writing. Everybody wants a template to write a letter, but you can't make a template because every letter is different. Every issue is different. But you have to have a fundamental understanding of the Uniform Commercial Code in order to write a letter. And I want everybody to learn how to do that, write their own letters, and not just copy somebody else's.
Okay, New York, is that it?
Yes, thank you.
Okay, thank you so much. Okay, Leiderspiel.
Yeah.
Did you have a question? Go ahead.
Okay, Gene, I was listening to one of your other recordings, and it was talking about abstract of title.
Yeah.
What I'd like to know is, where do you get that abstract of title if you're in Canada?
Title company.
The title company that issued the mortgage, is that what you're saying?
No, the title company that insured the mortgage.
That insured it, okay.
Call them up and ask them who has the abstract of title.
Okay. And
the reason you want The reason you guys are not winning in court is you got to do an abstract of title.
Right.
The reason being is that there never was a mortgage.
Okay, well, I got a question in relation to that. I have a first and a second mortgage, but my first mortgage is really a line of credit. Is there still a note or a promissory note to that?
Same thing.
Same thing, yeah.
Okay, and one other question. Remedy at the IMF, is that a remedy for Canadians also?
Yeah.
Okay.
I don't know what you have up in Canada. Do you have a Secretary of Treasury?
Yeah. But do we get it from the Treasury or do we get it from the IMF?
Well, I don't know whether see here they did away with the Treasury. They moved it down to Puerto Rico.
Okay.
Timothy Gunther is the governor of the International Monetary Fund.
Gunther, yeah.
Not the Department of Treasury.
Okay. And the other question was related to, I was on this My Private Audio, and I can't find where you say there's names and all that information about Gene's site. So
You go to the top of the page and it says guest speakers.
yeah, I went to it after you told me that the last time, and I still, it's not there.
Click on it and you scroll all the way down to the bottom.
There's nothing to click on at the top, though. That's the problem. So have you got Toby's address, and I'll just email him directly? I know you don't want to give it to me, but
I don't have it in front of me. Gene, do you have it?
Well, you got to go. He doesn't want people emailing him. He wants to go through Skype. It's Toby.Butterworth.
Okay.
Just Skype him. Skype him and tell him you want to join the class.
All right. Thank you.
But you got to do it. You got to sign up before 4 o'clock. Everybody's coming in there after 4 o'clock.
I understand that.
And he's trying to run the projector, and he can't run the projector and we can't give the class because everybody's coming in late.
Yeah, I understand that.
You got to sign up before 4 o'clock. If you can't do it before 4, do it the day before then.
I was even trying to do it today, but I can't get the thing to come up properly, so I'll try again, thanks.
Okay, on My Private Audio, when you go myprivateaudio.com,
yes.
And I might add, yesterday they had some technical difficulties. I don't know what that was about, but the website wasn't coming up for a couple hours. But,
well, I'm getting it to come up and everything, but all those headings on the top are not there.
There's a black line, a charcoal colored line going across the top with links inside. One says Doug's A for V, one says guest speakers, one says John Stewart.
Yeah, that wasn't there. Okay, I'll mute out now. Thank you, and I'll try again and let you know before the call's over.
All righty.
Thank you.
Thank you too. All righty. Coke.
I gotta get in line, don't I? Okay.
Is that you, Jeff?
Yeah, I'll mute out and
yeah,
start.
I think you're coming up like second anyway, so.
Okay, honey.
Kokomoto is next. Hi.
Hey, Gene, how you doing?
I'm doing all right. How about you?
Oh, rocking, man. I got a couple questions for you regarding your last talk on Angelo's here. You mentioned the tax form A300. What is that? And
cash flow payments. Any cash flow payment over 10. Promissory note is a cash flow. That's why if you read FASB number 95, Statement of Cash Flows, it says when the note is deposited in a demand deposit account, it becomes the equivalent of cash. It's also in 1813 L1 of Title 12. Section 1813 L1. If you read Statement of Cash Flows, number 95, it says when there's a mortgage and the note is deposited, it becomes a cash payment to the depositor and a receipt to the bank, and a receipt to the depositor and a cash payment to the bank. Well, where's the receipt? Tell me you want the receipt for the deposit. You got funds sitting there and you're not using them.
Okay, and then you said, another thing you said that I'd like to clear up too, is you were talking about under the Standard Financial Accounting Standards number 95 and International Accounting Standards 7.6, and it sounded like you said Keating the inflows and outflows.
Yeah, inflows and cash flows.
Yeah, what is Keating? I don't know if what word do you think you meant there? Because it didn't come through, it blipped, the recording blipped.
Well, they're inflows and outflows.
Okay.
Which are assets and liabilities. See, that's what the balance sheet is, the 2046 balance sheet, but they won't show it to you.
Oh, and that's a balance sheet that they have and they keep?
Yeah, they have to fill that out and file it with the Federal Financial Institutions Examination Council. But you can get it off the RCS call schedules, call reports. You can download that off the internet.
I'm sorry, what did you say? You get it off the what?
You get it off the FFIEC, Federal Financial Institutions Examination Council website. Just type in RCS call reports, and the form will come up, and go look at it. That's where they record the cash payments and the call reports.
Okay, and then another question is with these bonds that we all filed, a lot of people like myself filed with the Treasury, okay? How does one look that up to see if it's active?
You mean the bond?
Right, you file that, the indemnity bond and the offset bond and all that good stuff. You let it cook for 10 days each and whatnot.
You send it into the Department of Treasury?
Yes.
Okay, they have 30 days to accept it.
Okay, well, that's been a year ago. I'm wondering, how do you find out if it's active? Or did they actually process it or toss it in the garbage, You
can go in there. There's a way to go in there and look it up. You can actually see what they're doing with it.
Okay.
I can't tell you that over the phone, but I can show you on a screen.
Okay. So in other words, stop by on Tuesday.
Yeah, they're actually, every time you send them something with your signature on it, they monetize it. And they're double dipping. I actually did on a credit card account, and I wrote a letter to this is Capital One. I did an international bill of exchange. They deposited it, and they showed me the endorsement. They actually time-stamped it and deposited it in the account. Then they drew it back out again. Then they deposited it again. They did this 2 or 3 times. And I wrote them a letter, and I made them redeposit it. What they're doing is you got to understand what they're doing is they're double dip. They want to see if you know what you're doing. They've already accepted the payment, but they're not recording it.
Well, I guess that's, how do you enforce the recording of it? Is that's where you file with the IRS?
Yeah, I told them, I said, send me the 1099 OID, and the 1096 will show who the recipient of the funds are, and then they credit it to the account. Because now they're liable for the tax on it. Because they made a withdrawal. They withdrew the funds.
And if they don't return it to us, is the presumption that they made the withdrawal, or is the presumption that we have to prove they made the withdrawal?
No, they made the withdrawal if they don't return it. That's the proof.
Okay, so then you just move to a default. An notary protest and a default.
Well, one of them I did a promissory note. They wouldn't send me the note back. I said, well, if you don't send the note back, then I did a notary protest. Defaulted them out. And I said, then I disputed the debt. And they credited it to my account. I made them credit it to the account. They tried to tell me that a note was a liability instrument and they couldn't accept it. And I said, well, then return it to me. If it's a liability instrument. Because if you endorse that for payment, it's not a liability, it's a draft. Go read 3-104E. If you endorse a promissory note, pay to the order, turn it over on the back and do a pay to the order of on it, it's a commercial draft.
Oh no, I didn't do that. I did not do a pay to the order of on the back of it. I did it on the front.
What? That's what I did. I turned it over on the back and did a pay to the order without recourse. Now they can't come back on me.
Okay. Is that a necessary part of it? Or, because we were taught to do it differently.
Do it without recourse. That's what they do.
Well, I think the better thing to do now would be just to write a money order rather than a promissory note.
Well, you can, yeah. It's the same thing. That's what the check is. That's what the bill is. It's a money order.
Now, Angela asked earlier, and you were talking about something else at the time, but when you do the money order, do you also flip it over and endorse the back?
When you do the money order?
Right, you flip it over.
Just endorse the front if it's a money order.
Okay, and then the back is blank.
Yeah.
Okay. And then one final thing I wanted to ask you about is you want to go in as a donor, or a donee? Is that it? Beneficiary donee? I think that's US 303,000 something.
Well, you want to be the donor because the donor has the power of appointment. Appoint him as the fiduciary trustee. Make him the executor.
Okay, could you repeat that? I'm sorry, I missed that.
Under 2038, 2041, and 2514 of Title 26, you have the power of appointment.
Okay, that's because I'm the donor?
That's because you're the donor. The Power of Appointment Act holder of the Power of Appointment Act was passed in 1951. Codified to 2038, 2041, and 2514.
Okay, and that's what gives us the authorization to...
You can make them the executor, and then they have to pay the tax.
Okay, so we don't want to be the executor. We want to make them the executor?
Yeah, if you go to 2002, the executor is liable for the tax.
Okay. So we want to make... Okay.
Be the beneficiary, donor beneficiary. Here, donor beneficiary, but you have to identify yourself as that.
Okay.
Otherwise, the presumption is the judge does a constructive trust in equity and makes the plaintiff the beneficiary. If you don't claim that, it's abandoned property.
Okay, now when you appoint the judge a donor beneficiary, when you appoint the judge the executor, okay, is it necessary to have some kind of an indenture or some kind of, like wrap it in a trust somehow so that they just can't sell your property for you nicely or something like that? I mean, what prevents them as the executor from, completely devastating your account?
You're the beneficiary.
Okay, how does that tie in, Gene?
I make them the trustee, fiduciary trustee, and beneficiary. And then under 3-605 of the Uniform Probate Code, I make them put a bond up. They have to put the bond up.
Okay, so it's the bond then that is the protection. I mean, if you go in there, say you're going. I'm trying to think of an example here, but let's just say you're going in for a large sum of money, and they could wipe you out with that.
Yeah.
Once they're the executor, I mean, they've got the power of God, don't they?
No, the grantor, the donor grantor does. The donor does. Because the donor holds the power of appointment. You can fire an executor. If you appoint him, you can fire him.
Can you rescind what the executor did?
Yes. Well, you can fire him.
Okay. And what type of responsibility or accountability? Say we do this now. We're in court. We're going to assign this to the judge, and he's going to be a really unhappy guy. What kind of an accountability is he going to have at that point in time? I mean, how do we hold him to that accountability? With the bond or with the bond that we would require him to put up?
His oath of office. He's already acting. If you identify yourself as a posterity and as a constituent member of the posterity and a sovereign, beneficiary of the constitutional trust, because the Constitution is a trust.
Which one? The Articles of Confederation, the United Colonies, the Declaration? Which one?
Both of them. All of them. All of the above. The Constitution, the U.S. Constitution is a trust.
Well, that's very interesting. I mean, as long as we don't have to worry about them destroying everything that we've got once they're the executor, that would sort of.
It works. It's worked every time I've done it.
It has, huh?
Mm-hmm. I made judges ran out of the courtroom and shut the court down.
Well, I would think they'd be pretty unhappy if they've got to pay the tax, huh?
You know what they did? They hired attorneys and tried to get out of it.
Oh, really?
Yeah.
Well, you must get out of it. With a
case.
I'm sorry?
They couldn't get out of it, so they dismissed the case. This is a criminal case, felony criminal.
Oh, you mean to violate something like? I mean, you're saying if they violate the executor position?
Hell yes. You could have them arrested.
And under that Appointment Act of 1951, I forget the other one that you said, that gives you the power to do the appointment, and that's what binds it in law?
You are God. If you're the donor.
And what ramifications does a donor have? That means I'm donating something as a gift, like my house?
Every time you give money to somebody, you're making a donation.
Okay. So my work and labor and energy is a donation to the monster.
That's right. How do you think they're running?
Okay, well, this fits together quite nicely. You know, I mean, it sounds like, are there any more steps that a person, I mean, basically it looks like you got to sign yourself, or you got to sign the judge as the executor. You've got to be the donee, or the donor. Okay.
You know what
You
happens?
got to do,
They
you
do
got
a
to do
con-
the 10,
they
you
do
got
a
to do the
con-
10,
they
oh,
do
go
a
ahead.
constructive trust and equity. The
I'm
judge,
sorry, Sid.
the judge does a constructive trust and equity, makes the plaintiff the beneficiary, heir beneficiary of your estate. He makes you the trustee. He does this behind the scene without you even knowing it. That's why if you don't do it, you're screwed.
Do these judges even know that's what they're doing?
What do you think?
Well, I don't know. That's a good question. You know, I mean.
Of course they do.
Okay.
Let me ask you a question. Go read 2203.
I'm sorry?
26. It says administrator and an executor. Don't all these courts have an administrator? They call him a
Right.
court administrator?
Right, yep.
That's an executor. He tells the judge what to do.
And that is his job, is to administrate what, the public trust?
Yeah. Your estate. The estate of the decedent. The all capital letter name.
Can the estate be considered a territory?
Yeah, it could be. It's contained. It's real estate. Property. And you're letting them control it because you don't know what's going on. So
Well,
what they
would
do is
make
they make you, and the reason they do a constructive trust is to give restitution and reimbursement to the plaintiff. Is that always what happens in the courtroom?
Yeah, we don't win anything.
You never win, do you?
No. It sounds like there's a lot to this, but then it sounds like once a person gets it down,
That's
really
why
have
you
a lot
got
of.
what they did on a loan is they're assuming title because you abandoned the property. That's why you got to go. See, if you read your original constitutions, they call it the local action rule. I sent this out to everybody that was in the class. You need to go into the class, and we'll get you these documents and read them.
Okay.
The local action rule. The only court that had jurisdiction over land was the county court. They called it a land court. They didn't call it property or real estate. They called it land court.
Well, when you say a county court, are you distinguishing that between a district court, like a state district court, or how do you determine whether? I mean, it's called the county court here in my town.
Yeah, that's it. That's the land court.
Okay, well, that's where they take you if they want to, start hammering on you. Into the county court.
But what you do is you go get a surveyor to come out. You know what the difference between meets and bounds and property and real estate?
Well, as soon as you call it property and real estate, it's colored. You now have a colored. Anytime it's colored, it's colored for tax purposes, right?
Yeah, what they do is they did on the deed of trust. They have a right of way, and the right of way is the township range number, township number, section number, and lot number.
Right.
They lay that over onto the meets and bounds, which is your direction and distance. See, under common law, they measure property, not property, but land. See, they called it land back then. They didn't call it property.
Right.
And land was legally described in distance and direction. Like they'd say 260 feet northwest or 390 feet north-south.
Yep.
And then they use landmarks, like they would say the 290 feet northwest at the tree. They would describe the tree, and then or a large rock as landmark. That's how they describe land. They weren't describing property; they were describing land. What does a deed of trust say? A deed of trust uses the word property. It doesn't use land. So what you have to do is get a surveyor to come out and do a survey on meets and bounds. Tell him you want meets and bounds, and he'll know exactly what all surveyors know this.
Well, I did one on my own. I did a meets and bounds on my own. I don't know if that's valid or not, but I took it from the quarter section corner where they referenced, but I used the satellite dimension. You know, the 45 longitude north by the latitude west, and then I went down from there and basically followed all their dimensions right over to my lot. And I didn't use any township range or anything. But a problem that I have, and I don't have a good answer to, is on the patent. Okay, on the original patent, it does say granted to the grantee in the county of, and he is, basically they said it was in the county, right on the darn land patent.
Okay, but you don't want to use the land patent.
Okay, that's what I was afraid you were going to say. After all that work I went through, but I still have to prove out an abstract, so I still need the land patent for that. But I mean, or at least I assume I do.
No, you don't. You don't need the land patent. Get rid of it, because land patents are based on military districts. They divided the United States up into 12 military districts. That's what your land patents were based on. You're under a military venue. So what you do is you go to a surveyor, get a meets and bounds, and he'll issue you an abstract of title, and then you publish it in a newspaper.
60 days?
You have title and ownership of the land by meets and bounds. And anybody who doesn't come in and lay claim to the property is excluded from claiming title and ownership of the land. Then you file a petition with the land court, which is your probate court. In your state would be the county court. In California, it's the probate court because they moved the county court. They made the probate court the county court. And you file a petition, and you get a quiet title on your property that you have title and ownership to it. They can't come in. That's how you make them produce the note. They're claiming that they own the land because of a mortgage, and they don't even have the note. They can't bring the note in there. Well,
yeah, but I don't have in my case, I don't have a mortgage. They still, force you to pay taxes.
Sure you do. If you got a deed of trust, you got a mortgage. Did you know a mortgage? Did you know a deed of trust is a security?
No. Well, I've got a warranty deed. It's not a deed of trust. It's just a warranty deed.
Yeah, what they do is they take a deed of trust is a security. They take the ad valorem tax that they collect from the warranty deed or the deed of trust, and they buy mortgage-backed securities with it.
You're kidding.
I can prove it.
And then what? Charge the profits to me?
Yeah, they're charging it to your. They're using your deed of trust to buy mortgage-backed securities.
Small world.
Go to it's right up on the Texas website. Just type in ad valorem tax, and it tells you how they do it. They go into a great deal. They take the deed of trust and the ad valorem tax, which is your property tax, and they take the revenue and they buy mortgage-backed securities using the revenue from the deed of trust.
Okay, but how can they do that when there's absolutely nothing whatsoever on the deed that grants them that authority?
Because a deed of trust, if you go get the Securities Handbook of 1933, it says in the securities, I'm talking about the SEC, Securities Exchange Commission. They have a handbook, 1933 handbook. It says when a deed of trust is in the hands of a third party, the managerial hands of a third party, it's a security.
So the only way that we can stop it is basically to get the deed of trust back.
Yeah, you know what? Yeah. You know what happened? One of my students went into court, and the federal district court judge told him, when you go to closing, take the deed of trust. Give him the note and walk out with the deed of trust. Do not give him the deed of trust.
Well, how does a person get the deed of trust back once they've got it in their grubby hands?
Well, you're the donor. You donated it, didn't you? Fire him. Fire the trustee. You know who the trustee is? The register. The county recorder. Fire him. Appoint a new trustee.
And a new government trustee?
Yeah, you got the power of appointment. You donated the property to him, didn't you?
And who would be a good choice to choose for that isn't going to make matters worse?
Well, let me read something to you. See, this is why you have to understand what's going on. Let me read this to you. Then you'll understand what's going on. This has been going on 1066 under the Norman Conquest in 1060 Norman Saxon Conquest.
Oh, we're going to talk about the military rule?
Okay, here's this is insinuation. INSINUATION. Insinuation under the civil law is the transcription of an act on the public registers, like our recording of deeds. It was not necessary in any other alienation but that appropriated to the purpose of donation.
So
alienation is a transfer of right, title, and interest. So what you're doing is transferring right, title, and interest in the property to the register by donation.
We donated our land to them.
Yeah.
Well, then that would make them responsible for this. There's another angle to make them responsible for this tax.
Yeah. Yeah, they really own there was a mortgage on the property before you ever got a loan.
Because, it's originally disposed of, according to the records, by the United States when they, signed it out to the territories. Supposedly, it was disposed. And if you look at the old land records, it says the destruction of the property, of the public lands, like the Northwest Territory and whatnot, supposedly sold into the private. But somehow they got it back, and it sounds to me, from what you're saying, they got it back when we filed our titles into the recording office.
Yeah. It's the only cure I know for being stupid.
Other than paying lots of money?
Well, yeah, what do you think makes you a tenant on your property? The county recorder is the landlord, and you're the tenant. Stop paying your property taxes and see who owns the property.
Well, how does that go? There's 4 states literally all the states, I shouldn't say all of them, but many of them, originally had that the lands in their state were allodial. There's still like 3 or 4 states that still have that in their constitutions. So that apparently must form a trust then? Is that the idea where it's like waiving your rights?
Yeah, they were divided. The United States was divided up into trust territories under treaty law.
Does the United States still consider itself territorial jurisdiction over all property, even if it's in private hands and even if that property is not registered?
Well, not technically, no. But everything is.
Right. Okay. So basically...
Is not what,
Okay, so we basically waived our rights then. That's what it comes down to.
The problem is the people. They don't know. They're giving everything away.
Yeah, we don't know what we're doing.
Yeah. What's your first clue?
Yeah. Okay. Well, I appreciate it, Gene. And I'll let you get on to the next person. I thank you very much. Thank you, Angela.
You're welcome. Thank you.
I'll mute out.
Okay. Moving right along, we have Southwest Wisconsin. Go ahead.
Hello.
Hello.
This is Chris.
Hi, Chris. Did you have a question for Gene?
Yes, I do. Thank you so much for all the work you do, and thank you, Gene, so much for what you're doing to help everybody learn. My question is, right now I have about 5 balls in the air. I've got our home that was foreclosed on and given a summary judgment, and we're supposed to have 6 months of redemption period, and that expires on the 30th of December.
They call that They
what?
call it a forfeiture.
A forfeiture? Is there any way to deal with that at this point?
Yeah, pay the tax on it. You know what? Anytime you have a forfeiture, you're involved in tax.
Well,
you didn't pay the tax. You didn't report the income. You know who has the lien on your property? It's not the lender. The IRS does.
Oh, so I can fix that with some IRS forms then?
You didn't report the credit that you gave.
I tried to do the OIDs, but I didn't.
Well, listen to what I'm saying. You didn't report the credit that the lender used to the IRS as a tax.
Okay.
So the people that are foreclosing on your property are acting as a tax collector.
I see.
Because you haven't identified yourself as the payor on an OID.
Okay, can you show me how to do that Tuesday if I join in the class?
I can show you how to do that. That's why you got to understand the uniform 3-105 tells you, or excuse me, 3 let's see, I think it's 3-105.
3-105, I'll read it.
It says, talks about the issuer. The issue is the first funds payment or first payment order. The issuer is the drawer and the maker. Aren't you the drawer and the maker on the note?
Actually, it's my wife.
Okay, your wife, then. Did you report that to the IRS as an original issue discount?
Well, I tried, but I must have did it wrong. We did the 1099 OIDs and sent in the A's and the
Did you file
OIDs.
an 8281? Identifying yourself as the issuer?
No.
Did you read before you filed the 8281 and the 1099 OID?
No, we had somebody helping us that was a tax preparer that has helped other people do them, and she never said to file the 8281.
But he doesn't read either.
Mm-hmm.
That's the problem with this Patriot movement. Nobody reads anything.
Well, and I didn't know what to read and where to read it at that point in time.
If you come to the Tuesday night class, I'll show you how to fill it out.
Okay, because I also have a civil penalty assessed against me for frivolous filing right now, and they're trying to garnish everything we have and levy.
Yeah, that's what they do.
Right. Yeah, for $5,000 right now, so they know we're down and they're trying to beat us down farther, I guess. But if I come to the Tuesday night class, you can help me with that.
Yes.
Okay, wonderful. I've also got my brother's home, but that should apply over there too. I've been out of work for a couple of years now and sick.
This applies to everybody. You're giving all your money away, not getting any of it back. That's why we're
I know. I've been studying a lot of different things. It's just studying the wrong things, I guess. But it sounds like now maybe I can do something about this before they have a sheriff's sale.
Yeah, the Apple 104 is the originator. Mm-hmm. Article 4A of the Uniform Commercial Code.
Mm-hmm.
4 Apple 104C defines the originator as the first funds transfer. You were the originator of the first funds transfer. You just haven't identified yourself as that.
Okay, so
by filing the proper paperwork.
Okay.
Now the IRS can give you a refund. That's how you redeem. That's what true redemption is. Is a return.
That summary judgment I have sitting there, I can't just appoint the judge then as the executor of that thing and have him do it all, can I? At this point, or
you can do anything. You got the power of appointment, but you're not doing anything.
Okay, well, I didn't know that I didn't know I had that power, I guess.
Go read Title 26, sections 2038, 2041, and 2514. I have a law review, volume 52 of a Tennessee law review, that it actually says that the donor he's the holder of the power of appointment.
Mm-hmm.
Plus the donor on your loan. You were.
Yeah.
Okay. And you're not doing anything. Oh, you're not paying anybody.
Can all this then, even to the judge, be done in writing and sent notary presentment?
Now you do a letter rogatory, which is what I did. I did a car loan on a car. I appointed the judge, the trustee, and executor, and I identified myself as I did this for somebody else. I didn't do it for myself.
Mm-hmm. Okay.
I identified him as the heir beneficiary to the legal estate of the decedent. And since he was attempting to do a taxable termination under 2603, I made him the trustee, and all trustees are liable for the tax on a taxable termination. When you divest somebody of their title and ownership in the property, that's a taxable termination. And the trustee is liable. That's why I make him the trustee.
Well, would I make the clerk of courts a trustee too, and everybody else there, or property tax people, because they aren't paid either because I've been unemployed. So
what I would do is make the administrator. You know who the administrator is?
No, I don't, but I guess one could find out.
The administrator is the one that tells the judge what to do. He's called the court administrator.
So I should call and find out who the court administrator is.
Yeah, you appoint him as a fiduciary trustee.
Okay, just by a letter, I can do it. Do I have to cite the?
Yeah, you know what happened when I did this letter to the judge?
Yeah.
He took the case off the calendar.
Oh,
the
wonderful.
Attorneys put a motion for default judgment because this guy didn't show up in court, but we made a special. Mm-hmm. We didn't show up in court. We didn't make a general appearance. Mm-hmm. So you don't have to show up in court. That's a general appearance unless you make a special one. And you need to. I've got another article that goes into what the difference between special and general appearances. Mm-hmm. You got to learn how to do a special appearance so you don't give the court jurisdiction. You don't contract with them.
Well, I went in there as their special appearance, and I did use the family name trying to do that. He said that he put in the record that no one appeared, even though when I used that special appearance, and said that my wife didn't appear. And he still basically he struck all our pleadings that we put in and affidavits and everything else. And
on the public side?
The attorneys asked him to, the attorneys asked him to strike everything, and he allowed them to do it. So
yeah, but did you file the papers with the clerk?
Yeah.
So you never do that.
Oh, okay.
You do it on the private side. That's where your common law is. That's why you gave all your power away.
So that's where I screwed up. Okay.
You got to file them with you. Don't file them. You give it. I sent them registered mail to the judge.
I see.
And the judge appointed the judge, the trustee, and executor of the estate. Guess what he did? He issued an order, and it's in the docket sheet. I can show you the docket sheet. He ordered they put in a motion for default judgment because we didn't answer their complaint.
Mm-hmm.
They foreclosed on a $60,000 car loan. Well, they took the case off calendar. They dismissed the motion for default judgment, and they dismissed the motion for a writ of possession to repossess the vehicle. and they took the case off the calendar. The attorneys are no longer in the case. Now this car company that he bought the car from keeps calling him up, wondering if he's going to surrender the car. The attorneys are no longer involved in it.
Right. So I can get probably with the right letter, the rogatory letter you talked about, I can get them to back off on this whole thing.
You can make them run. I made them run out of the court. They shut the court down for 3 months.
You could help me with that maybe Tuesday night at the class then?
Go into that, yeah.
Okay, great. Well, I've got about 5 different Toby Butterworths here on the Skype. Is he the one that's
he's the
T.S.
moderator.
Butterworth?
Yeah,
What?
you gotta Skype him and tell him you want to join the class.
I will. Is it T.S. Butterworth or Toby Butterworth alternate United States or Thousand Oaks or Australia or Manchester? There's about 5 of them.
It's Toby Oaks.
Thousand Oaks. Thank you, Angela.
You're welcome.
I appreciate that. Hey, guys, I can't thank you enough, Here I've been going to Winston's route, doing everything else, and trying to learn everything I can learn, but most of the stuff I've learned is incomplete.
They're putting liens on people, and they're getting thrown in jail for it.
Yeah, I know. I didn't put liens on any person. I put a common law lien on her house. I actually sold 5% of it for 21 pieces of silver, and they transferred the whole thing over to this other person.
What you need to do is a quiet title action. Do a meets the boundaries, and when the court rules that you have title and ownership, they're gone. They're history.
Okay. So I'll have to work on that. I don't know if I can get it done before in 14 days, but if I can just get the judge appointed and get that done, and I can do that on property taxes too, right? Appoint them as
You got the power you can do, the donor has the power of appointment. Okay. You're the holder of the power of appointment, and nobody's using it.
Okay, well that sounds like the
it's
magic, magic bullet there.
Guys attack you and you don't use it.
Okay, well great. That makes sense.
All right, can we move on?
Yes, thank you so much. I really appreciate it.
Thank you. Thank you. Okay, we're going to move on to V Gully. Wait. V Gully. It's not unmuting. Hold on a second. Okay. Go ahead, V Gully. Did you have a question? Did you fall asleep? V-G-U-L-L-E-Y. V Gully. Speak up. Hello.
Oh, that's me.
Oh, great. There you go.
How are you, Angela?
Oh, fine, thank you.
Great. I just wanted to tell you, one, I love what you're doing, and thank you for doing this. And hopefully everyone will donate something to your website.
Oh, thank you very much. That's very kind of you. I appreciate that.
Anytime.
I love you, too.
Gene, I was listening to the talk show you did with Angela last week, and you were mentioning that this guy who had paid a credit card, and you were going to tell him show the forms and how to get that back from the DTC. And I don't think I saw that on Tuesday, so I'm going to be on next Tuesday's call again. But I was kind of hoping maybe you could do that this coming Tuesday, because I know you can't do it on this call.
Yeah. That's the easy one to get rid of. You get all that money back, too.
Yeah, that's what I'm hoping that you'll at least go through, because I know you get I've been looking up all the stuff that you talk about, and it's hard to follow you sometimes because you go so quick. But I'm hoping at least you'll go through the forms and say, okay, after you fill out this form, this is where it gets mailed to. Because I know it goes to the DTC, but does it go to the Depository Trust Corporation, or does it go to the other DTC?
Trust company.
Okay, company.
Company. Seed and Company is what it's called. CEDE and Company.
Okay. Well,
they own both sides of the credit card account.
Okay. All right. Well, I'm going to just look forward to seeing you on Tuesday. And I'll give someone else an opportunity to go ahead and ask you a question. Thank you.
Thank you.
All right.
Okay. We're going to move on to Southwest Wisconsin. Go ahead, Southwest Wisconsin. Did you already say what you needed to say, or what? Okay.
Is that for me again?
Did you have your hand up?
I did before, and then we talked, and
okay, so
I got off the phone.
Okay.
You don't need me again. Okay.
Oh, okay. All right, we're going to go on to Utah. Go ahead, Utah.
Hey, Angela. Hey, Gene.
Hi.
It's Fritz in Florida. I'm concerned about Leroy Michael, and I keep losing you. I was hoping I could give you my number, and you could get back with me about rescue doctrine for Leroy.
All right.
Let me give it to you. It's 561. You got a pen and paper?
Go ahead.
667-8823.
Okay.
All right, I'm standing by. I'm just absorbing. I think everybody should, when you're trying to ask Gene a question, let him talk and not try to talk over him, and let him finish what he's saying, and you get a lot more knowledge that way. And the other thing is, read it! Just like you say, Gene, from TRW. Read it. Read it.
Okay, thanks, Fritz. Okay, Jeff. Go ahead, Jeff Quorum.
Angela, how are you?
Hello, thanks. Honey. I don't know where that feedback's coming from.
Yeah, I don't either. Gene, I got a question for you, sir.
Go ahead.
All this carrying on and fussing and carrying on and all this no-note stuff and all this bull going on with these foreclosures and whatnot, why couldn't a guy call the mortgage company and get a payoff amount? Make yourself up an invoice and put it in your file over here on one side of the account, and send the IRS a 1099-A, which is an acquisition for funds. And you've got the invoice sitting over here. Put it in your bank that's in your house. Send them a 1099-A for an acquisition for the funds, and just pay the thing and quit fussing and fighting and carrying on.
You could do that, yeah.
See, I can't understand why everyone wants to do all this fussing and fighting and carrying on with all this show me the note and this title stuff and all that stuff when you can just pay it. You're the creditor in bankruptcy to the corporate United States.
There's only one thing wrong with that. It's not a loan. It's an investment contract.
Is it still not a debt?
Well, the question is who owes who.
Well, what do you care if you just do the 1099-A? Whoever sends you the payoff, that's who you make it to on your 1099-A form, and you send it to the IRS. Let them go take care of it. They're your bill collector. They're the ones that's supposed to pay your debts.
Yeah.
What do we care? That's not our business to fuss with all that stuff, is it?
No.
Them people work for us, and that's what they're supposed to do, is collect the debts, and then
make them a trustee. File a Form 56. Make them a trustee.
That's exactly what we have to do. We have to file a 1099-A, a 1096, a fiduciary statement, send it to the IRS, letting them know who the one is that's controlling everything, which is you, God, okay, and tell them to do their job. And then you don't have to do all this defensive stuff. You don't have to worry. You don't have to fuss. Well, what's the book say? Agree with thine adversary while thou art in the way with him, right?
Right. Make them an exec. Now they have to pay the tax.
They have to pay it all. HJR 192. I know it's been repealed. It's still there in the statutes at large.
It hasn't been repealed.
It's all there. We're the creditor. They have to pay all of our bills. They even pledged that they would pay all of our bills because our mothers pledged us with the birth certificate. So that makes you the creditor in bankruptcy. Just pay it. Quit arguing with these people. Send them the 1099-A, and now you are the sponsor of the funds. You get it all back.
Yeah. That's what I've been trying to tell everybody.
They get paid on the public side. We get paid back on the private side.
Right.
You talk about a win-win situation. There's no sense in getting fussing and going to court and all this stuff on these foreclosures. Am I wrong?
No, you're absolutely right.
We don't need to go to court anymore, do we?
No.
All we have to do on everything, every charge we get for everything, if you don't want to go through all of the 1099 or the acceptor for value on your utility bills, sit down at the beginning of the year and write up a business plan and find out how much it's going to take to run your business. Mine happens to be called Jeffrey A. Quorum. It's a trust. Okay? And at the beginning of the year, I can write up a business plan, put that copy of that invoice in my file, and send the 1099-A to the IRS, and they will fund my business for that coming year.
Yeah.
The Small Business Administration does the exact same thing. They just don't tell you what they're doing. They're still going in, and they're getting into that fund, which is your Social Security number or whatever. Maybe you working through a trust that you've got an EIN number on.
Yeah, tax credit, unified tax. You got a $3,500,000 unified tax credit on the estate side, and a $1 million unified tax credit on the gift side. So you got about $4.5 million, let's say $5 million in funds sitting there, and they're using them because you abandoned them.
Yeah.
Do you know anybody that's done this?
I know someone that is doing it as we speak. And but here's the thing, folks. Everybody on this call, and I listen to all these calls. I can't tell you how long I've been listening, just like all the rest of you. I'm no different than the rest of you. And we all, every time we want, well, do you know anyone who's ever tried it? Do you know anyone? Because we're all, I tell you what, we are all frightened to death of this IRS people. Until we get it in our heads that they work for us and we don't work for them, and we grow some kahunas and quit operating in fear and start operating like God and the power that we have in us, nothing's going to happen. I'm telling you, I'm in the same boat with all the rest of you. So I got to thinking today, why don't you just keep here sitting and doing what you've always done, which is nothing, and just see if you don't always get what you've always got, which is nothing. You know, we can't all wait for Gene to do something and and make a mistake and see him go to jail and say, oh, daggone, Gene, that's too bad. Thanks for being a guinea pig for all of us. By the way, what mistake did you make? Well, go screw yourself, people. I'm not going to tell you what mistake I made. Go do some study yourself. Go take on some responsibility for yourself, people. I'm in the same boat with everyone else. I'm as guilty as everyone else. But I'm going to fix it. By the way, Gene, they got brand new 1099s for this year. I ordered them online the other day. They came next day. I didn't even order them next day. I got on the computer. It was all I could do to even figure out how to do it. I'm not a computer guru. I ordered my 1099As. I ordered my 1096s. You don't have to order. You don't have to get the 1040 forms and the 1040V vouchers and the fiduciaries. You can just print them out right off the computer. So I ordered those forms. They came the next day, and I'm going to move forward with this thing, and I'm going to do just like McFadden said. Go get your money before you ever start doing your business. You know?
Yeah.
Shoot me down, please.
Is that it?
You got the right idea.
Okay. I appreciate it.
Thanks
Sorry,
for coming
Angel,
on, Jeff.
I
don't be sorry for what? Don't be silly.
I get a little upset sitting around watching everybody say, "Well, has he tried it? Have you tried it? Has this guy tried it? Has everybody?"
Well, that's
Sometimes you got to fall down the steps and know what it feels like to fall down the steps, and then maybe you won't fall down the steps no more.
That's right.
If you get the fear of falling in your head, you'll watch. You'll even be more prudent about how you go up and down the steps once you knew what it felt like to fall, but until you knew what it was.
Not a pile of poop at the end of the stairs there.
Yeah. So sometimes we just have to have faith, and we have to believe something because it just makes sense. And it's an individual thing, you know, each and every one of us. So anyway, okay, I'm sorry for ranting and raving, Angela. Thank you.
Don't apologize, you silly guy.
Okay.
You're always welcome to talk. Anything you want to say is
Well,
open forum tonight.
Gene Keating's the guest, and I'm not going to step on his shoes. Okay. Thank you. I'll listen online.
All right. Bye. Okay. Widerspiel. I want to say the Wiener Schnitzel.
Some people do.
Sorry.
Can we get a list of what we'll be dealing with on Tuesday so we're half-ass prepared and have an opportunity to read some of this stuff ahead of Gene presenting it?
Yeah, we're going to go into we're going to talk about the OID, how to do a pay to the order of, to pay your bills. Report your income as credit, which is why you guys are all having problems. Everything's a tax bill. And you got to report that as income. But you got to do it right. You need to read the 8281. Go read publication 1212. That's the publication that tells you how to fill out an OID. It tells you got to file an 8281. Go read the instruction booklet on the 8281. You should read the 8281, the 8282, and the 8283. That's how you identify yourself as the issuer. And you need to read 3-105 and 4 Apple 104 of the Uniform Commercial Code. Then you'll understand what an issue and what an issuer is. And Title 15, Section 78CA8, small a, parentheses 8, defines what an issuer is. These are things you need to know before you start filing all this paperwork. Are we still on?
Yeah.
Yeah, we are.
When you read the Uniform Commercial Code, this is why I keep telling you. You got to know commercial law, trust law, tax law, and accounting. All of these 4 fields are related. They're all interconnected. You can't learn one without the other. When you understand all 4 of those, you'll have yourself a remedy.
And will you be talking about recoupment also?
Yeah, recoupment is counterclaim.
Okay.
If you look up the definition of the word recoupment, it means counterclaim. When you recoup something, it means a counterclaim.
Well, do I understand what recoupment really is? If I was to win with recoupment, they would have to repay me all the money I put into the mortgage?
Yeah. That's a set-off. It's a set-off or a counterclaim. But then you have a right, if you read 3-306, you got a right to the proceeds and a possessory and property right in the instrument. What instrument? The note. Why aren't you making a claim to the proceeds from the note? That's why when you read 16 CFR 433.2, it talks about that they take it subject to all defenses and claims that the buyer can assert against the seller. They can't be a holder in due course because they took it subject to your defenses and claims, but you're not raising them.
Right. Well, did I understand it correctly when you said the abstract will basically show you that it's a fraud in itself, and all you have to do is take it to a judge and ask, or
it'll show that the mortgage was paid in full.
And then you would ask for quiet title, no?
Yeah, because they can't come forward and prove that they own the property.
Right.
Because you made a quiet title action.
So,
if they don't and dispute it and show proof that they own the property, that they have a claim, and they're not going to do that because they can't produce the note. So
now, am I correct in assuming that the reason that they're not producing the note is they haven't been paying the taxes?
They haven't produced the note because there isn't one.
They chopped it up through mirrors or whatever, or through.
It's not a note; it's a security.
Okay.
Go read Title 15, Section 78, CA10.
CA10. Okay.
It says a note is a security and an investment contract. It says a security is an investment contract. It defines what a security is.
And does all this apply to a second mortgage also?
Sure.
So if you make your case on the first mortgage, it just follows suit with the second, eh?
Yeah, here's what recoup means. It means to recompense for loss or expense. Means to deduct, to cut back.
Okay, and I have a copy, the ninth copy of, or the ninth edition of Black's Law Dictionary. Am I going to be getting a bunch of different definitions than, say, through the second edition?
What I do is go into the etymology dictionary. That gives you the source of the word.
Etymology.
You have that as a defense, but you're not. If you don't raise them, you waive them.
Right.
Well, everybody's waiving their defenses and claims. That's a claim.
Yeah.
Well, if you don't raise it, you waive it. And then people sit and complain, well, you can't win in court. Well, you're not doing it right. That's why you're not winning.
I guess that's why we're not lawyers, too.
All these lawyers know that.
Yeah.
I'm really giving them an education, I'll tell you that.
Anybody else has a question? Wait a minute, Gene. Anybody else has a question? Press *8. Okay, now go ahead, Gene. Sorry.
Yeah, they're never the same. They don't know the law. They don't know tax law. They don't know commercial law.
Do you have lawyers in the States that have like a QC or a KC behind their name? which stands for Queen's Counsel or King's Counsel?
Well, Esquire, it's the ESQ, which means the same thing.
And they're also through the Bar of England, eh?
But I make a contract with them. I do it on the private side. I contract with them.
Oh, yeah.
I do the same thing to them that they do to you. Does it work? It's worked every single time I've done it. Because I know how to do it.
Yeah.
I make them prove up their claim. They have to present the instrument. Did they ever send you the instrument?
No.
Hell no, they don't. When they make a presentment, they say you owe money. I say, well, give me the instrument. Show me the instrument.
Or show me how much I owe.
Well, they show you how much you owe, but they don't show you the instrument. That's because they don't have it. And their authority, I can challenge their authority to make the presentment. They're making the presentment on behalf of somebody else.
Yeah.
They can't do that.
Angela, I have a question.
Sure. Oh, wait a minute. Wait a second. We've got 5 people in line. I'm sorry. You have to hold on.
I thought you said if anybody else has a question, unmute yourself.
No, I said press star 8, and that'll put you in the queue.
Well, I guess I can be in the queue then.
Yeah, star 8 on your phone. Sorry about that.
Okay, sweet.
Thank you. Buddy.
We'll spank you after the call.
Okay. Your Wiener Schnitzel, did you have anything else?
No, I'm done. Thank you.
Okay, thank you. All right. Northern Florida. Go ahead. Did you have a question for Gene Keating?
Hi, how you doing? I went to the county county recorder today to record a notice of reservation of rights, and they looked through it. The person that sits in the front desk right there, she's read it, tried to interpret the law that was on there, and she's like, she looked at it like, this is not it. I can't record this. And then I said, you need to get your supervisor. And then the supervisor came in. They told us that you can't record this because the people brought this stuff here before, and you can't record this here. And then I said, is there a law that says you can't record this here? Because I see no evidence to support that claim. I need to record. I want you to record this. Are you making a legal determination here? And then
you know what you should do before you record a document? You should get the statutes that tell you what documents they have to record. And I'm going to tell you what they are. If they're photographically reproducible and they're required to be recorded, they have to record them. I've been through all this.
They told me to look at Title 28, Section 222, and I did that. And under that, it pretty much went into detail as to what kind of things can go in there, from a list pendant to affidavits and the notice of things that have to be required by law. It had to be recorded and required by law. But we couldn't find any statute, and I couldn't find anything on the USC that said that supported our claim, actually, basically, that we could put this notice on there. It's hard to find, I guess.
Get their bond. Find out. Get a copy of their bond from the Secretary of Treasury.
Oh, Secretary of the State? You mean the Secretary of State? Treasury?
No, the Secretary of the Treasury. Usually they file their... Find out where they file their bonds. They usually file them with the Secretary of Treasury.
And you're talking about the county recorder or the clerk of the court or whatever?
No, I'm talking about the treasurer. Most county employees file their bonds with the treasurer.
So you're saying that I should get the bond for the person that told me no?
Yeah, and then find out who the surety company is, the insurance company, and file a claim. Watch how fast they record it.
I filed a claim saying that I tried to record a document that needed to be recorded, and they wouldn't allow me to do so.
Yeah.
I think they said that there's a lawyer that they told us, oh, well, we're going to have to fax this to a lawyer, and they're going to tell us whether this is legal to be recorded or not. And then they never got back to us, and we didn't call them back, but it's been like it's been 2 days. And we just, we're like, okay, well, they're making legal determinations over there. What if they're just going to be gangsters? It's like asking the hen in the hen house to behave. We don't want to go to the hen to the fox. Sorry.
Go after their bond. I got a judge fired off the bench.
So I can file a claim, but what's the basis for my filing of the claim? I mean, like, they're gonna ask me. I'm pretty sure that I'm gonna have some kind of cause to file a claim, right?
For breach of fiduciary duty.
Breach of fiduciary duty? But we didn't assign them any fiduciary duties.
Do a Form 56. Make them a fiduciary trustee.
Oh, you mean the clerk recorder, the county clerk recorder?
Yeah, the registrar, yeah. They call them registers.
Right. The deed, because they do the deed registers.
Marriage certificate.
Right, yeah. So then,
just do a Form 56 and record it with him. So it becomes a public record. Now he's a trustee. Now he's working.
What if? Yeah, what if they don't record the Form 56? They're not going to want to record something that's going to prejudice them or,
Don't make assumptions.
Take exception.
I bet you I can go down there and get it recorded.
You said don't make assumptions.
Don't make assumptions. You keep assuming. My words do not leave my mouth and come back to me void. Quit being negative. All you people are being negative. That's why you don't get things done. You need to read Zero Limits. If you're not getting things done, clean on yourself. Go read Zero Limits. And tell me I'm wrong.
Where do I get that document?
Toby, my guy that's running my he had a foreclosure. They were going to foreclose on his property Wednesday. He cleaned on himself Monday and Tuesday. And they called him up and told him that the foreclosure had been canceled for 2 months. Go get the book Zero Limits and read it, and you'll understand what's going on. Who's really controlling things? You're controlling everything.
Okay.
You control you are God.
You're right. We were really thinking about doing that. Before you mentioned that, we were thinking about doing the bond. That was the next step for us. We just were kind of hesitant to doing that move yet, But it's not really a big deal because it is their bond, not ours.
Go get the book Zero Limits and read it.
I have another question, if you don't mind, real quick. This movement that is pretty much growing and taking, a lot of momentum in different directions. And I respect everybody's point of view. But just like I was looking, because there's a certain crossroad that we as truth seekers have to sort of speak, kind of like, meet that juncture where you either go for the pot of gold or the impenetrable armor. There's kind of like I see two roads where you can go for the 99 ID and the birth certificate and claim all this fictitious money from a fictitious fraudulent government. We know they're fraudulent. We know this is all fake and it's not real money. We just, we know what's going on and learning and more. And, and going in that route and as an agent of the government and knowing that it's foreign entities and yeah, okay, they may have put a certain price tag on every one of our births and all of that. That's all understandable, and I go and I totally 100% see that, and that's a pot of gold. I see that as a pot of gold. And then on the other side, we have the fact that attorneys don't have licenses, and that, you know, you can build an impenetrable armor, you know, that you cannot be touched, you know. And I'm seeing, like, either you go that route or you go after you know, this somewhat, because it's very unattainable. This money's always been somewhat like the thing, you know, that the Jews and the Judaic whatever, and this, because these are the guys who control the entire, you know, tapestry, all of it, and so that, you know,
these people aren't controlling anything. The American people are allowing themselves to be controlled because they're focused on what's outside them and not what's on the inside. The inside controls the outside, not the other way around. If you're not winning in court, it's because your focus is outside yourself. Clean. Go read Zero Limits and Clean and tell me I'm wrong. Ask Toby if it works.
Okay. All righty. Let's move on. We got 7 people lined up. Okay. Is there anything else? North Florida?
Thank you very much.
Thank you. Okay, Central Arkansas. Go ahead.
I guess that's me. Gene. Oh, good. Thank you. First of all, Gene, thank you very much for all your incredible knowledge. And I got to tell you that it's difficult for at least me to grasp it all, since it's obviously so extensive what's going on. And a big thank you to Angela for hosting this, and all that she does for us. And for those of you out there who are listening and gleaning information and knowledge, I'd really appreciate it if you could all contribute a few dollars to Angela and send it to her to help her out to continue doing what she does so awesomely. But Gene,
thank you so much.
Oh, you're quite welcome, darling. Gene, I'm kind of curious about the estate, and it's something that is a bit difficult for some of us, and especially for those of us who may possibly be immigrants and naturalized. And I'm kind of curious. I know that, you know, David Clarence came out with some things saying that, the immigrants, or at least it was my understanding from listening, or what I thought I heard, basically people who are naturalized have no estate and are not executors, and are. I'm just kind of curious about your knowledge about that, and how does one who is a naturalized person
you have an estate. You know what estate means? It comes from the word status.
Right. Yeah, I remember you saying that before now.
Okay, so estate has to do with your status. Well, what's your status?
My status is I'm a human being.
Well, if you're not claiming your rights, which are remedies, then you don't have any status.
But I've done that, and they just ignore me.
Okay, but when you say they ignore me, what do you mean? And what
they don't respond.
Okay, what have you done, for instance?
Well, for instance, I'm in foreclosure, or I have been in foreclosure, and I've filed suit twice now. This is the second time that I filed suit on them. And right now, the status of the court case is that it's the judge pretty much ignored everything, all the laws that I presented. That they anyway, I'm in appeal right now. I'm in the appeal process right now. So that's kind of where I'm at in terms of that.
You need to do a quiet title.
Yeah, I've heard you say that a couple times tonight, and I think that's an excellent idea. I'm just not absolutely sure about how to do that either yet at this point in terms of that.
But you need to do it out of court. You need to do it in the land court.
Okay, and file that with the county clerk?
Well, you file it with what you do is and you publish it in a newspaper.
Okay.
You know how they do when you sue somebody in Admiralty, they publish it in the newspaper, and if you don't answer, you're in default?
Yes.
When they do a forfeiture, I'm telling you, if you start doing what they do, you're going to start winning in court. I do to them what they do to me.
Oh, that certainly makes sense.
Okay, you publish it in the newspaper. If they don't come in there and lay claim to the property, then they can't say that they own it. I don't care if there's a mortgage on it or not. They have to bring the note in, and they can't do that. That's how you force them to do it.
I can do that despite the fact that this court case is ongoing.
It doesn't have anything to do with it.
Okay.
You should have done this before you ever did. What you should do is get a surveyor to come out and survey your property.
Okay.
Do a meets and bounds.
Right.
That's distance and direction.
But do you have to link that historically?
No.
To the...
Just do the meets and bounds.
Okay.
That's your land description, not property.
And then do a quiet title on that.
You do a quiet title on the land, not on the property. Get property word out of your mouth, because property is real estate.
That's statutory, of course.
That's statutory, and what they do is they overlay real estate or property onto your land, and they control your land. Once you get title and ownership of the land, they're gone. They're history.
Right.
I don't care. They can bring in all the claims they want. If they don't prove up their claim, they can't do anything.
Yeah, but I've asked them to prove up their claim in the court case, and they absolutely refuse.
Yeah, but you didn't do it through a quiet title.
That's true.
You didn't prove your title and ownership of the land. Not property or real estate, but land. And only a land court can do that. And your county courts are your land courts. Go into your original Constitution. It talks about land courts. What they did is they have two constitutions here in California. One of them was passed in 1849. And in the 1849 Constitution, they talk about land courts. And then they passed the 1879, and then they took the word, they talked about county courts. Then they took the word county court out of there. They didn't abolish them. They just quit talking. They don't talk about them anymore. They moved the county courts into your probate court.
Right. Kind of like the federal overlay of the federal overlay of the zip codes and whatever.
Yeah, they took the federal government and overlaid it over onto the states.
Right.
That's the same way. When you take the overlay away, they're naked.
I like that thought.
You expose the fraud. They don't own the property. You do. You own the land, the meets and boundaries. But you've never claimed it.
What about homestead? What about the original homestead laws?
Well, that's what the homestead's based on. Land.
Okay.
What does it say? Bureau of Land Management.
So
what you used to do is homestead the property. Then you would apply for a patent or a land grant. But they were based on the land, not on property. So they've changed the terminology. They talk about property and real estate now. You want to stay away from those terms.
Yes, sir. I understand that.
All your rights, inalienable rights, are grounded in ownership of land. Understand that. If you never understand anything, understand that.
Right.
Your rights are grounded, your inalienable rights are grounded in ownership of land.
Which the lawyers try to take away from us. You know, it's unfortunate that
Well, they don't take it away so much as you give it away. Quit giving your land away. People complain. I say, quit bad-mouthing the IRS. Quit bad-mouthing the government. Quit bad-mouthing the lawyers. See, you need to read Esther Hicks. Whatever you focus on, you create. People are they don't focus on what they want. They focus on what they don't want. And guess what they create? What they don't want.
Well, is this a book by Elizabeth Esther Hicks?
Yeah, Esther and Jerry Hicks wrote a book called
Ask and it shall be given.
Yeah, ask and it shall be given. You're focusing, what people do is focus on what they don't want. I don't focus on it. That's why Zero Limits is the best. This whole universe runs on love. You know what love is in music? Harmony.
Yes.
And when you're in harmony with the universe will give you anything you want. Are you getting this?
Yes, I am. That's a wonderful thought, and I love that. Yeah.
Okay, when you clean out the subconscious mind, see what you do is you have three minds. You have a conscious, subconscious, and superconscious.
According to Freud.
And you have information and data in those three minds. You need to get all that information. That means you let go. Don't have any intentions whatsoever. Just totally relaxing, clean. I love you. I forgive you. I thank you. I'm sorry. Thank you, memory. I appreciate you, memory. I'm grateful, memory. I thank you, memories. And watch what happens. When you clean out, it's like cleaning a virus out of a computer.
Gene,
your whole outside reality changes.
I haven't listened to the last talk show with Angela that you did yet, and I've heard about this already once, and I want to get this down.
Get the book Zero Limits. Dr. Hugh Lin, he cleaned out a whole ward of criminally insane people. They were so violent, they were criminal, they were rehabilitatable. They couldn't be rehabilitated. He healed them up. In 6 months, they were all gone, out of there.
Sounds awesome. I love you, I forgive you, I thank you, and what was the fourth?
I love you, I forgive you, I thank you, I'm sorry.
I'm sorry.
You know who needs to hear that?
All of us.
You. You do.
Yes. I do.
I need to hear that. I don't. When you forgive yourself, you know why other people won't forgive you for wrongs you've done to them? Because you don't forgive yourself, not the other way around. You know why people don't love you? Because you don't love yourself. Start loving yourself. You need to hear that. You know how many people don't? That's why all deaths are suicide. You know why? Because people don't love themselves.
Yeah.
That's why you got to hear that. Okay. I love you. I forgive you. You forgive me. You know. That's why people kill themselves, because they won't forgive themselves. Because they feel guilt. You know how many people are carrying a guilt complex around?
Well, yeah, I understand. I do forgive myself because I realize how ignorant I am in most cases, especially with most of this law that you're talking about. That's terribly difficult for me because I'm not really structured that way.
Well, see, what they did is they passed over it's called the local action rule. If you get into my class, I'm going to go into that this next Tuesday. It's called the local action rule. They haven't abolished it. They just covered it up, and you can't waive it. And the local action rule has to do with venue. And venue controls subject matter jurisdiction, not the other way around.
What exactly is venue? I've heard numerous different things about venue, and I explored that some in my case.
Venue is the court that has jurisdiction to hear the case. And because it's local, and it involves land, only the land court can foreclose on land. And that's not what they're doing.
But can you specify forgive me, can you specify in venue exactly what jurisdiction that you're, I mean, can you specify admiralty or, for example, I specified in my venue,
land court is your probate court. That's where your common law is.
Because they treat us as dead entities.
Yeah, because they moved the probate court under they moved the county court. It used to be in the county courts. Every state, if you go read your original constitutions, it talks about county courts. Those county courts are your probate courts. And they probate land. And if you do a petition and file, in California, they moved them under the Superior Court. They took the county court and one county judge that made a probate court out of it. Then after, in 1879, when they redid the Constitution, they eliminated that language. But it does talk about the probate court. So they're talking about the county court, because under the original Constitution, it was the county court. It wasn't called the probate court. It was called a county court. And county courts are land courts.
Well, that's where I've been looking for some remedy, but unfortunately they have pretty much ignored me. As David Clarence says, the barflies ignore me. As a matter of fact, they wouldn't even grant me a hearing because they know they don't want me in their courtroom.
Get out your fly swatter. They can't ignore a quiet title if you do it right.
And
go get your meets and bounds. Go get a surveyor to survey your property. Do a meets and bounds. Once you get the meets and bounds land description, file a petition, and then publish it. Publish it in the newspaper, in your local newspaper. So that people will know that if they don't come in here, if you publish something and they don't come in here, then they're excluded. They can't come in afterwards. You got them.
I hope it's that simple. I really do.
Since when is the truth complex?
You're absolutely correct. Thank you, Gene.
Doesn't it say in the scriptures, know the truth and the truth shall set you free?
Yes, it does.
Is it ever complex?
No, the truth is never complex. You're absolutely correct.
So you got your answer.
Thank you, Gene.
You're welcome.
Thank you. Okay. Next up, New York. Go ahead, New York. Go ahead, New York. Perhaps you have a mute button. There you are. Thought that was you. Go ahead, New York. We can hear you talk. I can hear them making noise in the background. Go ahead, New York. All right. Well, I guess New York doesn't want to speak up. Background.
There he is.
Where?
I guess New York doesn't want to speak up.
There he is.
There you heard feedback. Going once, going twice, going 3 times. Is that you, New York?
Going once, going twice.
Good grief.
Is that you, Mark?
Okay. We're moving on. John B2. Go ahead. John B2.
Okay. We're moving on. John B2.
There you go.
Can you hear me?
John B2.
Yeah, can you hear me?
Yep.
My question is,
you got to get up real close. I can't hear you.
My question is,
you got to get up real close. I can't hear you.
I think that So it has that line open that has status.
Yeah, let me go through here and mute some people out. You're all, please mute out *6 if you're not going to be talking. Getting a lot of feedback. Otherwise, I'll have to mute you here manually, which I am doing. Okay. Go ahead, John B2.
Okay. My question is twofold. First question is as pertaining to credit. Whenever you get a presentment, saying that you owe an amount when it pertains to credit, what can you do to riches? Hello?
Yeah, go ahead. What's your question?
I was wondering how could you what is in place that can be done to negate the resentment that has been given to when it pertains to a credit card company?
By doing a pay to the order of. Or you can do a letter rogatory. Ask them if they're making a presentment on behalf of somebody else, which they are.
Yeah, they are.
Tell them you want to see, write them a letter rogatory and ask them for the 1099 OID on the account. You want to see where the source of the funds are. Whose credit is it?
It's mine.
Well, then make them show that.
Okay.
If they file an OID, they're going to have to show you as the payor, and they're the recipient of the funds. So where do they get? Do you owe them money? If they're using your credit.
Exactly.
Tell them you have an OID that shows them as the recipient of the funds.
Mm-hmm.
And tell them you got a 1096 and an OID. And you have a Form 8300 that shows that they're the recipient of the funds. And that they owe the tax on it. Ask them where their check is for the tax. Tell them you want them to send you a check for the amount of the interest on the principal, which is what the bill represents. The credit card bill is the interest on the principal. And tell them to send you a check for the interest on the principal so that you can credit it to their account and zero the account. Otherwise, you're going to report it to the IRS as contraband. Do you understand what I just said?
No, I didn't. You said a lot there, and I was trying to keep up with all the things you said. You said the 1099. I did.
Tell them that you want them to send you a check for the interest on the principal. You're the payor. You're the creditor. They got the money from you.
Would it be done with the method that you said? Put it in a letter.
Yeah. Write them a letter and say, I want you to send me the OID that shows where the originator of the funds was.
Okay. Well, let me ask you this, Mr. Keating. What if you received a
You're breaking up. Your voice is breaking up. Are you on a cell phone?
No, I'm not. What if you received a notice from a deputy as far as them filing some type of action in court?
You mean, are you talking about the credit card company, or usually it's an attorney?
Yes, it is an attorney, yes.
Okay. You come on to class Tuesday night, and I'll show you how to do a letter and get rid of the whole thing.
Okay.
They don't even send me bills anymore.
Angela, will you have the link up on the site?
Yeah,
it's up there. It's on. If you look on guest speakers, scroll down to the bottom, you'll see the link.
Okay, greatly appreciate it. Second follow-up question is dealing with the IRS.
Same. Do you know the IRS has a DUNS number?
I didn't know.
Data Universal Numbering System. That means they're a privately owned trading company. That means they have a taxpayer. Send them a W-9. Tell them you want their taxpayer identification.
Wow, that's some feedback there.
Yeah, it was.
Okay. Are you having fun, Gene?
If you're not having fun, you're not doing it right.
That's right.
You know anybody who's ever sent a W-9 to the IRS to ask them what their taxpayer identification number is?
No.
Huh?
No, but I like it. Okay, John, is there anything else? John B2.
No, you were saying send a W-9 to them?
Yeah, and ask them for their taxpayer identification number. And tell them you want their DUNS number, too.
Okay.
All right, great. Thanks so much. We're going to move along now. Southwest Wisconsin, go ahead. We've got 10 people in line. Can we move it on? Please have one question and make it as succinct as possible.
You already answered it. You can move on. Thank you.
Okay, thank you. South Texas, go ahead.
Hi, Angela, Gene. Appreciate all the entertaining information here. Gene, I heard you talking the other night somewhere, and you were speaking about the land, and you mentioned it here about the meets and bounds. My issue is a property tax. I got a judgment against me. I finally got the money to pay off the land. They tried to auction off the double wide, and I've got a warranty deed on the land here, and I've had since '83. It's been in the family, and it's got the meets and bounds included. I don't have to get a surveyor, I suppose.
Now you got to do a quiet title.
Okay.
Or did they send you a tax bill?
Oh yeah. I got a judgment against me, and the auction was held last week, and I mean I dug up the money for the land, but they got the double wide on a separate issue. So it's still going to go back up for auction. Nobody wants a double wide anymore, I guess. So, but so I just want to get it out of the property tax rolls totally, you know.
Okay, do a quiet title action.
Okay, does that kind of override their judgment deal or anything else?
Yes.
Cool.
They only own the right of way. They don't own the land. They own the property, the real estate, which is the township section number. You got a township number, range number, section number, and lot number.
I don't have any of that. I've got meets and bounds, actually. I've got a track number. I'm sorry, I take it back. I've got a such and such survey, A-da-da-da, county, track number 2.
That's the overlay. They've overlaid their right of way onto your land.
But on the second page of the warranty deed, it's got it refers to Exhibit A. So Exhibit A is the meets and bounds. Yeah,
it's distance and direction. That's the difference.
Yes, sir. That's what it is.
And it's land. That's your land description, not your property description.
Right.
If you go into you don't have deeds of trust?
I've just got a warranty deed.
Okay, usually in the warranty deed, it'll give you a township, range number, and lot number.
No, because it's a really, really small town, so I guess I'm far enough away from what supposedly is a really small town to where the only thing it's got is, such and such acre tract out of a larger acre tract in a certain survey in the county.
Okay, is the auditor sending you the bill for the property tax?
The law firm that represents the county tax, whatever, appraiser.
Okay, ask them what their do a letter rogatory. Ask them where their authority is to represent the auditor.
Actually, I mean, I've done that before, but I mean, they already did a judgment against me, so I don't know if it's too late for that or not. It really doesn't matter. I don't think anymore since they've got a judgment against me.
Okay, who's they?
The county tax people.
Okay, how'd they get a judgment?
Because I had bugs in my head or something and didn't pick up certified mail.
Okay, but you said they got a judgment. Who issued the judgment?
The county.
The county what?
Good question. Got it right here. The county that's a county here is a plaintiff, and actually, I guess the law firm that is working for him is the one that printed it all out. So,
well, what you can do is when they went down there, they sold the property. Who bid on it?
Well, they did. I got the money to pay the taxes on the land. The double wide was being auctioned separate, but nobody bid on the double wide. So supposedly it's going to come up in another month or 2 months or 3 months and go back up for auction again.
Okay, who's the auctioneer?
Sheriff's Department, as I understand it.
Okay, they're selling the double wide as a fixture, right?
Right.
You know what a fixture
real
is?
estate or whatever they call it. Yeah.
Yeah, fixture is whatever is attached to the land.
Exactly.
I'd go down there and bid on it with silver dollars.
Okay.
Go get the sheriff's. Go get his oath of office.
All right.
Take his oath of office and record it.
Okay.
And then after you record it, do an acceptance for value on it. Do an acceptance for value. Then you become a party to his oath of office.
Do an acceptance for value on his oath of office?
Yeah, then record it.
I don't know how to do that.
You get on my Tuesday class, and I'll show you how to do it.
Okay. And of course, the main deal, I want to do the quiet title on the land itself, so that and I don't have to worry about these property tax bullcorn anymore. You know what a presumption is? It's a guesstimation.
No, it's under go read 1-201. Presumption. The trier of the fact shall find the fact to exist unless evidence is put into the record to show a contrary finding. Who's the trier of the fact?
I am.
Well, no, the court is. Oh. Whoever's issuing the judgment. You never rebutted the presumption that they own the property. That's what a quiet title does. It rebuts the presumption that they own the property.
Cool.
They charge you the taxes if you own the property.
Okay. Yeah.
Yeah. Tell them to go take a hike.
That's what we all need to do.
Yeah, like what's his name? Jeff summed it up. I'm a pit bull. I've been that way all my life. You ever seen a pit bull fight?
Yeah, they're bad. Yeah.
They used to call me Brutus. I used to kill pigs with my bare hands.
and with your teeth?
No, I'm serious. I used to kill Russian boar with my bare hands.
Break their necks or what?
Yeah, break their necks.
You bad, man.
That's a big, thick neck.
That's right. Did you have to
All right, good.
First is the first question, but
I had a bull mastiff that weighed 210 pounds, and he used to tree them, and I'd jump on their back and bulldog them.
Wow.
That's why I am the way I am, and I don't know what quit is.
Okay.
Well,
and if you do it right, you will not lose. You need to clean on your. Go get the book Zero Limits and read it.
I heard that. I got to get it.
Get it, read it. Watch what happens. You win. I guarantee it.
I'll be working on that tomorrow.
You don't have to do anything.
I'll be looking forward to Tuesday night. Thanks. I appreciate it, guys.
Okay, thank you. All right, moving on. North New Jersey. Go ahead. Go ahead, North New Jersey. Did you want to ask me a question?
I'm here. I was just writing down the time so I can come back and listen to the tape.
Okay.
Jean, do you know how to unrecord a deed?
Yeah, fire the trustee.
How do you do that?
Send him a letter.
The trustee being the county clerk?
Yeah. He's the trustee, the registrar, whoever the county recorder is. Fire him.
What do you say in the letter?
I'm hereby terminating your trusteeship.
That's it?
Yeah, you got the power. You're the grantor settler on the deed of trust. You're the grantor.
Well, there's no mortgage involved here. This is
what you have to do is write a letter
saying
that you're the holder of the power of appointment under the Power of Appointment Act of 1951. It says you have the power of appointment. You're firing him as trustee of the deed of trust. The deed of trust is a trust.
Okay. And I just send it, registered or certified mail?
Yeah.
And if this is coming from the executrix or from home?
No, this is the donor. Tell him you're the donor, beneficiary, and heir of the estate, and you're firing him.
And how do I find out if this worked?
I've done it. It's worked every time I've done it.
All right. What should I get a letter back? You know what I'm saying? How do I know?
I haven't done that particular thing because I don't have any property right now. Every time I've done a letter rogatory, I've been successful with it. Attorney, to give you an example, I'm living in a house right now in Rancho Cucamonga. The woman moved out and gave me a grant deed to the property because she didn't want to keep it. She's
Are you paying property taxes?
Huh?
Are you paying property taxes?
Well, let me tell you what happened. It's a gated community. It's owned by Hawthorne Association.
Mm-hmm.
So the attorney sent me a letter. I'll go over the letter. I'll show you the letter. If you come to the class Tuesday, I'll show you the letter.
Okay.
I wrote the letter to them. They said I owed $34,000 in back taxes. And I sent them the letter. I did a conditional acceptance on proof of claim. If you want, I'll read the letter to you. I got the letter right here.
Sure.
Okay.
Hello?
Yeah, he's getting a letter.
Okay, here it is. Oh, wait a minute. That's not it. Got the wrong one. Okay, it says Law Offices of Pamela Moore, 528 North Glasgow, Orange, California. Alleged account number. Dear Mrs. Moore, I am writing in response to your recent correspondence regarding an alleged assessment in the amount of $3,590.07 through May 2010 plus delinquent dues of $305.32 for legal fees and costs. I conditionally accept your offer to pay the delinquent assessment of legal costs upon proof of the following facts: that San Bernardino County does not own the property located at 9530 Springbrook Court, Rancho Cucamonga, California, by transcription, recording an alienation of the grant deed appropriated to the purpose of donation under insinuation of California and Roman civil law. 2, that San Bernardino County as a qualified heir and trustee has paid the capital transfer taxes under 2511A, taxable terminations under 2601, 2603, 2611, and 2612, and 6901 of Title 26 of the United States Code as a heir and donee. 3, that California as a territory of Mexico was ceded to the United States in pursuance of the provisions of the Treaty of Guadalupe Hidalgo on February 2nd, 1848 by Nicholas Trist. 4, that I have a written contract or agreement with the Hawthorns Owners Association wherein I have agreed to pay tax assessments to the Hawthorne Homeowners Association as a contract obligation, and that Hawthorne's Homeowners Association is authorized by law or statute to collect this tax. 5, that Pamela Abbott Moore Law Offices has a bond to collect taxes in the form of revenue for San Bernardino County. That Hawthorne Homeowners Association is authorized by San Bernardino County to collect taxes from homeowners by law or statute. That Pamela Abbott Moore Law Offices at 528 North Glasgow in Orange, California is not a privately owned trading company registered with CCR, Central Contractors Registration, under the DOD, Department of Defense, and the Defense Logistics Information Service, with a DUNS number and bonded insurance, cage code, NAICS number, PIC code, SIC code, POC, point of contact, MPIN number, Marketing Partners Identification number, and TPIN, Trading Partners Identification numbers. Failure to respond to the above maxims will be tacit express procreation that Hawthorne Owners Association is not the real party in interest under Federal Rules of Civil Procedure 17A and the California Civil Code Section 367 and San Bernardino County to assess a tax on the property which is the subject and object of the delinquent assessment, that the Hawthorne Homeowners Association does not have subject matter or in personam jurisdiction under Rule 12B 1, 2, and 6. The definition of fraud given in 37 Amjur II 144 through 146 is unquestionably the concealment of material facts that one, under the circumstances, is bound to disclose may constitute fraud. Indeed, one of the fundamental tenets of Anglo-Saxon law of fraud is that the fraud may be committed by suppression of the truth, expressio veri, as well as by suggestion of falsehood, suggestio falsi. The principle in law of fraud as it relates to non-disclosure, that a charge of fraud is circumstances to speak and disclose his information but remain silent. Section 1206 of the California Commercial Code Whenever this code creates a presumption with respect to a fact, or provides that a fact is presumed, the trier of the fact must find the existence of the fact unless and until evidence is that supports a finding of its non-existence. Number 9, failure to respond, rebut, or silence to the above maxims and facts is tacit, express procreation that the law offices of Pamela Moore are not telling the truth, are committing fraud upon this court of record, and expressly agree to all self-imposed and court sanctions, legal costs, and they further agree that they have committed forgery by misrepresentation. See People versus Martinez, 161 Cal App the 4th, page 754, by fraud in the inducement and in the factum under 3305 B and C of the California Commercial Code. Each answer, if not specifically rebutted in detail by the law offices of Pamela Moore and Hawthorne's Homeowners Association with clear, concise, ambiguous terms, as stated in Gould versus Gould, 245 U.S. 153, within 14 days of receipt of this certified instrument, it will stand as final. There was no evidence that Michelle's signature on the Lavilla trust deed was not genuine. Michelle admitted that it looked like hers. She also admitted that the defendant had her sign a number of documents. Nevertheless, a forgery conviction can be based on a document with a genuine signature. Forgery is committed when a defendant, by fraud or trickery, causes another to execute a document where the signer is unaware, by reason of such trickery, that he is executing a document of that nature. Let me move down here. That's it.
That last one was really a winner there.
I never heard from them.
That last one says that if you sign a deed or you accept a deed,
yeah,
that when you're the grantee, you don't sign it.
I never heard from them again. They haven't done anything.
I thought you were in Pennsylvania. You will move to California?
Yeah, I'm in California now.
I see. So you're not suggesting I send that to the Register of Deeds? No.
Yeah.
Yes?
Send that to Register of Deeds. Just put your wording in it.
Mm-hmm. But that's not firing her.
Oh, if you want to fire her, yeah, just do it. Say I'm terminating the office of trustee of the deed of trust, document number, whatever the document number is.
Mm-hmm. So in other words, you're saying two separate letters.
Yeah.
Okay, they do the one to fire.
I wrote to. I never heard from him again. Never did anything.
I found a statute in New Jersey that says that a purchaser of real estate, I'm not sure if it said real estate, purchaser of, say, real estate, can go to the assessor with evidence of transfer, and which could be a deed or a contract of sale, and the assessor has to put on it something called an assessor certificate, a stamp of some sort. And then he has to note in his books and maps, if any, that he has done so. Then the very next statute after that says that if a county recorder is presented with a deed that doesn't have an assessor's certificate on it, then they have the right to put an address on it. So I thought that was the remedy, that we could unrecord the deed that way. I don't know what that sounds like to you.
Yeah, but don't record the deed.
No. Yeah. Do you think I need to do both this, a contract of sale and a deed, or one or the other?
Well, I do both.
Okay. I did both.
Then make up
I had the contract of sale dated for a year or so ago,
There's no more requirement that you register a deed. Everybody does that because they don't know what they're doing.
I know, but the problem is you can't unrecord them.
Well, do another deed then.
Yeah, but the only way to unrecord the deed, well, so what you're saying is that the only way I could get any remedy there is to present it to the assessor, that second deed to the assessor. But otherwise, I'd have to record that second deed to get the first deed off, and I'm back to square one.
Yeah, but you don't want to do that. You fire the trustee.
Yeah.
On the first deed. The donor has that power, but it's how you word the letter.
Right.
You got power, you're just not using it.
So
Or you're scared of these people. Everybody, everybody's scared of these people.
Yeah,
I back them down every
really
time.
true.
Every single time I've done a letter, they back down.
What would you do if you had a certificate of tax sale recorded against your land?
Well, I've never gotten into that position. That's what they were starting to do. They were going to. You read the letter. Well, you didn't. I didn't read you the letter they sent me.
No.
They didn't do anything. And this is. I sent this letter May 14th. June, July, August, September, October, November. That's almost 8 months ago.
Mm-hmm.
They haven't done anything.
Well, so is there anything I can do about the certificate of tax sale?
Yeah, I would do what I said. You have to do a letter to the register firing him. You got a certificate of tax sale from who?
Well, the tax collector sold the taxes to one piece was sold to the town. The town bought it, and the second one was U.S. Bank.
Well, there's two things you can do. Do you have redemption rights?
They're up on the one. They're up.
So what are they going to do? Are they going to kick you off the property, or what are they going to do?
Well, if they decide to, they can. I guess they can try. I have no number on the house or any address that they can locate me at and send me a notice.
Call them up and ask them if you can still redeem the taxes. I'll show you how to do it.
Okay.
Call them up and say, I want to pay off the tax bill. And I'll show you how to do it. Make it stick.
Okay.
Then you tell the U.S. Bank to go take a hike.
Would I call U.S. Bank and to ask them? Or the town?
Well, I would call the town and see what they say. If they tell you U.S. Bank owns it, ask them if how did U.S. Bank pay for it?
Oh, I don't know. I wasn't at the sale.
Well, you should have gone to the sale. I bet you U.S. Bank didn't put up anything.
How could they do that?
Well, because you weren't there to watch what was going on. Like at these foreclosure sales. They're supposed to get a certified check or cash. They never get certified check or cash. And nobody challenges the sale. A bona fide purchaser for value. Therefore, there was no bona fide purchaser for value, so therefore the property was never sold.
Well, what do I do? Ask how they paid for it?
Yeah. How did they pay for it?
And they'll know that? Would I do an Oprah request for that information?
Yeah.
Okay. That would be easy.
They can't accept anything if it's taxes. They can't accept anything but gold and silver coin. Ask them if they have an oath of office on file.
For whom? The tax collector?
Yeah, ask them where is this in? What state are you in?
New Jersey.
Ask them if they've got what is New Jersey declared to be legal tender and payment of debts?
I don't know. I would imagine silver.
Oh, he's telling you to ask them.
Well, ask them what they consider. Oh, in the Oprah request.
Yeah, just ask them. Say, I don't want to know what you will accept. I want to know what you've declared to be legal tender and payment of debts. You need to read Hager versus Reclamation District 109.
Okay.
U.S. notes, Federal Reserve notes, only applies to debts in the strictest sense. Taxes are not debts; they're involuntary contributions. Exacted under state law, they can only use gold and silver coin to pay them.
That was Hagler versus Reclamation?
Yeah, let me give you the site. I've won over a dozen cases arguing the money issue. They asked me to come up and testify before the Senate Finance Committee as a monetary expert. I never lost the money issue. I've never used it on a mortgage case, but I've won it on every case I've used it in, every other case.
That Hagler or what?
Hagar.
Hagar?
I'll have it for you. It's 111 U.S. 701.
111 U.S. 701.
701. Hager versus Reclamation District.
Hager?
Yeah, this is a U.S. Supreme Court decision.
No, wait. Hagar or ER?
No, it's Hagar. Okay. Here's what it says. I'll read to you what it says. The acts of Congress making the notes of the United States a legal tender do not apply to involuntary contribution in the nature of taxes or assessments exacted under state law. Hello?
Huh?
But only to debts in the strict sense of the term. That is, to obligations founded on contracts, express or implied for the payment of money.
Would that be on a record? If I ask them that question? I don't think that they need some sort of a record.
What do you mean if that would be on
well,
the
record?
record?
Well, if I did an Oprah request, an open records request, that question would be answered in some sort of a document that they have on their records.
Okay, what question is that?
Well, you told me to ask what's their payment, what the state requires for payment.
What law, what is the state of New Jersey declared to be legal tender in payment of taxes? Don't use the word debts, use the word taxes.
Mm-hmm. And that's something that should be answerable in an Oprah or like a FOIA request.
Yeah. And okay. Tell them you want the statute that says that. And tell them you want a copy of their oath of office to uphold the Constitution, Article 1, Section 10.
Okay. All right.
I was in I did this last year. I was in Texas. I filed a lawsuit. They had an $800 filing fee. I refused to pay the filing fee, and they had a show cause hearing of why they weren't going to dismiss the complaint because I didn't pay the filing fee. You know what I did? I filed a promissory note. Did you know they gave me a receipt for it? I gave them a promissory note as payment for an $800 filing fee. And they accepted it, and they gave me a receipt.
So, once I get this information from them, then what do I do with it?
Well, get the information first, and I'll tell you.
Then tell you. Okay. All right,
I'll help
do
you
that.
with a letter.
Okay. Now,
Dean, did you have to do anything to get them to take that promissory note? Did you have to say anything?
Oh, I went there, recorded. I went into the hearing, the show cause hearing to dismiss the claim for failure. And I said, Your Honor, I paid the filing fee with a negotiable instrument. She says, I know. She says, why are you bringing it up? She already knew it. They accepted it. They gave me a receipt.
Why is that? They won't do that for most people. Why
Well,
did
that's
they do
because
that
I put a memorandum of law in support of the promissory note.
Thank you. And what did it say in that brief?
It's 21 pages long.
Oh, gee.
I can blow anybody on the water. I know more about money than anybody on this planet. I learned it from Merle Jenkins, how to argue the money issue. Amos Bruce taught me how to argue the money issue.
Yeah, well, that's you. That's not us. We can't go into any court and do what you did. I mean, Jesus Christ, it's going to take 10 years to learn half the stuff you know.
That's
not
right,
even
Angela.
Now.
Well,
what happened to the truth is simple?
Well,
yeah, really.
The
Didn't
truth
you
is
say
simple.
that about an hour ago?
Yeah, it still is.
But 21 pages is not simple.
It's simple for him because he's got a photographic
In his
memory.
head, yeah.
He can consume like 10,000 words a minute or some ridiculous thing like that. And he retains all that knowledge, which is not the normal, person's educational level. I mean, it's not mine.
I can do it, you can do it.
Yeah.
How many years? I know. Read Zero Limits and we'll be able to do it tomorrow.
Yes. Clean on your whole thing will go away.
Okay. I wrote it down.
If you don't believe me, just do it. Don't have any intent whatsoever about anything. Just clean on yourself and watch what happens.
Okay.
That's right.
I have another question. I paid off a mortgage. Can I get that money back?
Yes. The answer is yes. But you got to file a tax return to get it back. I can show you how to do that.
Okay. Is that Tuesday's class?
Yes. I'm going to go over that.
Okay.
Okay, look, we've got like 11 people in line waiting to ask a question. We've gone 2 hours and 43 minutes. How long you want to stay on, Gene?
We can, I'm still...
You good to go?
Yeah, well,
let's go then. I'm not stopping until we're done or until you pass out or whatever. All right, North New Jersey, is that good enough for you? We can move on.
Okay, thank you.
Thank you so
I do have a question. How do I sent an email to Toby Butterworth last night from your website, Angela, asking if I could get onto the class.
You got to
never wrote back.
You got to register before 4 o'clock.
And you just Skype him. You have to Skype him.
Okay, now, but somebody else said there's like 6 different Butterworths. How do I know which is him?
He's the one that says Thousand Oaks.
Thousand Oaks?
Uh-huh.
Okay.
The only one that says Thousand Oaks on there. That'll be him. You're welcome. Okay, we're going to move along. Oh, Kokomo Joe, go ahead. Did you have a question?
Hi, can you hear me?
Yep.
Oh, now I'm unmuted. Hello?
Go ahead. We can hear you.
Ahead.
All right. Okay. All right. Boy, you know what? I had a question, and I totally changed it since we got off onto this other subject here. In this state, it says money, and maybe you can translate this for me, Gene. The money of account of this state shall be the dollar, comma, cent, and mill, and then it's semicolon, and all accounts in public offices, comma, and other public accounts, comma, and comma, except as provided in statutes 806, and all proceedings in court shall be kept and had in conformity to this regulation?
There is no money of account. There is a money of exchange. Ask them if they want the money of exchange or the money of account.
Okay, why do you say there's no money of account?
Because they did away with the dollar. The dollar is the quantity of gold or silver in coin form.
I thought money of exchange was the dollar. I had everything reversed?
Yeah, the dollar is the money of account.
Dollar is a unit of measurement.
Yeah, it's a unit of measurement. It's not tangible, it's an intangible. The dollar is defined by the Coinage Act of 1792 as 416.5 troy ounces, and 23.23 grams of gold is a dollar of gold. If you don't have that much gold and that much silver, you don't have a dollar. So how can you have a money of account?
So they've got it in the statutes here that we're supposed to be paying them in gold and silver?
Go read Article 1, Section 10. It says no state shall make anything but gold and silver coin a tender and payment of debts. You're going down there paying them with paper.
Well, then this statute isn't even lawful.
Yeah, how about that? They get me in court, you ought to tell them, I say, issue me an order me to pay it, and I'll pay it whatever you order me to pay it in. And I'll take it up on appeal, and we'll see if you have the authority to do it.
Well, they did. They said I got to pay them in money. And, of course, here it defines money as money of account. And is there anything that annexes money? In other words, does that, what you just, the Coinage Act, does that specifically state money of account shall be gold?
Yes. It defines what it is. It tells you what a dollar of gold is and what a dollar of silver. Go read it. Never been repealed.
This statute's absolutely unlawful.
Yeah, what's your first clue?
Or what they're requiring us to do is unlawful.
Yes, what's your first clue?
Yeah, hey? Unbelievable. Well, okay. My question was basically a cloud on a title, okay? We didn't know any better when we were kids and bought the house, all right? And what they did is they essentially lied to us, all right?
We got too soon old and too late smart.
Exactly. All right. What they did is we bought the house in the middle of the year. So they said that, well, okay, you gotta pay the taxes. We'll make a deal, and you gotta pay the taxes for the rest of the year. Okay. And I think they're doing that to a lot of people. All right. And then what they did is they said, well, and as long as we've got the mortgage, you got to obey all the city ordinances. Okay. And then what they did when they put it on the top, what they did is they talked the grantor. They said, well, for your protection, you want to make sure that it says that on the warranty deed. Okay. So what it says is taxes levied in the tax year. That's all it says. And it says ordinance or something about following the city ordinances, but that one didn't mean much to me. But it's the taxes. That's what they said. Taxes levied in the tax year. Okay. So that's a cloud on the title. Will a quiet title get rid of that?
Yes. Do it on the meets and boundaries, or meets and bounds.
Okay.
You did it on the property, not on the land.
Okay, now...
They're not taxing your land, they're taxing the property that they have a right-of-way on.
Right.
That's what you guys don't understand. They're not taxing your land.
Right, they're taxing the real estate.
Yeah, what's your first clue?
Well, when I was in court, he asked the attorney, he said, he asked him if I was the owner. And the attorney said, yeah, as far as we know, he's the owner. Okay, well, sure. There's owner and then there's paramount owner. Nobody tells you that. Apparently the state is the paramount owner, so.
They own the real estate. That's because you donated it to them.
Yeah, as the donor.
Okay, once you donate it, you can undonate it. Fire the trustee. The donor has the power of appointment. All you got to do is tell them what your authority is for doing that. You got all this power and you're not doing it.
Now,
You're not doing anything.
Does the accept for value work for the taxes? Because if the tax, what was that you just read? One of them is a debt or strictly a debt. So
it's only debts in the strictest sense of the form. Those that are obligations by contract.
Okay, what is the county? Okay, what is the county tax or the city? The taxes for property. Is that a debt by the strictest sense or not?
Involuntary. Here, I'll read it again. The acts of Congress making notes to the United States a legal tender do not apply to involuntary contributions. They're involuntary contributions in the nature of taxes or assessments, but only to debts founded on contract, express or implied for the payment of money. Do you have a contract with them? No, you don't.
Okay, so then you're saying that it's a debt?
No, I'm saying it's an involuntary contribution in the nature of taxes or assessments. Involuntary contributions and taxes have to be paid in gold and silver coin. This is a California case, 1884. U.S. Supreme Court decision. Never been overturned. They were assessing taxes on swampland. And the guy argued it had to be paid in gold and silver, and the Supreme Court agreed with him.
Okay, what's the name? Is that Haggerty case?
Hager versus Reclamation District, 111 U.S. 701. It's on the internet. Just download it and read it.
Okay, dynamite, man. Thank you again. I'm out of here. Thanks, Angela.
Read the third paragraph.
All right, thank you. He'll read the third paragraph. We'll all read the third paragraph, Gene. Okay.
Thank you. I love you. I thank you. I'm sorry. I forgive you.
Yeah, well, thank you. That's lovely. Leaderspiel, go ahead. Leaderspiel.
Hey, how you doing?
Schnitzel.
How you guys doing?
Great.
I got a question for. Well, actually, I was listening a little earlier about that fella wanting to know how to forgive. He didn't really know the equation to forgive.
You have to forgive yourself.
Well, no. You know, there is an equation to that. And the equation is the teachers taught the teachers, who taught the teachers over time. And in your forebears in your family, your forebears taught your forebears, who taught your forebears over time. Forgive them, for they know not what they do.
Well, that's the implication of it.
That's the answer.
Well, when you forgive
as far as you're concerned here, I don't want to argue with you. I just wanted to make a point here. A lot of people are phoning and asking you questions. But what you should, these people that live in California should really know about King George III, who laid out a covenant on this land in 1763. And part of that covenant was, anyone born unto this land is sovereign. Nobody shall ever override that now or in the future. Now, this is very important for all you people down at that end to know this. King George III was married to Queen Anne. And this covenant has been put away for over 250 years, which has silenced the people. So let's get this straight here. Now, if you are sovereign, the rules do not apply on your land by nobody. And if a judge rules against you in any way, shape, or form, he will go to jail for a minimum of 14 years. Now, that's the truth. And you know it because you can feel it. And I'd like everybody out there in this air to realize that that is the truth. And all this paperwork is just an invitation to contracting. You see, everything is based on money. And once you give up the money, if you've got faith, you know that Jesus already paid the price. Jesus just happens to be my brother. Sounds a little bit out there for most of you. But the truth is, if he paid the price, all you have to do is ask, and you shall receive. Most people go through God. That is not the avenue to go. The avenue to go is through Jesus to get to God.
Okay, I tell you what. Let's save that for another call. I'll let you have more time. Right now, do you have a question for Gene?
Well, not really. I'd just like to see everybody. There's a lot of bickering here going on about paperwork for somebody else, when in actual fact, when you're sovereign, the rules don't apply. So therefore, you already own all your land. And if they deem to come and try and take it from you, all you have to do is be peaceful and stay in your position and let them do what they have to do, and then stay in your home and take peaceful possession and forget all the garble.
Okay. All right. Gene, what do you have to say about that?
He's right, yeah.
All righty. That it?
Yes.
Oh, okay, we'll move on. Cleveland, did you have a question? Cleveland.
Hello, can you hear me?
Yeah, go ahead.
Okay. That was some speech that we just heard. But I wanted some information, maybe just someone to talk a little bit slower. If Jean could give me, I want to file the quiet title on my land because my home is in foreclosure, and I'm trying to look at any way I can to save my home, doing it pro se. So if you can just help me with quiet title, I would appreciate that.
Get a surveyor.
Okay.
Do a meets and bounds.
What is it? Are you saying leaps or what word? I don't get what word you're saying.
Meets. M-E-E-T-S.
Okay. So the one
actually M-E-T-E-S.
Oh, okay. Meets and bounds. So the survey I had when I bought my home 20-some years ago, that's not the same survey. This is a different type.
They've overlaid the property over onto your land.
Okay. And what did you say about distance and direction?
That's what meets and bounds is.
Oh, okay.
Distance and direction is measured in feet.
Okay, so I get the surveyor and then?
Do a meets and boundaries.
Okay.
Meets and bounds it's called.
Meets and bounds, okay. On the land.
Yeah, tell them you want an abstract of title.
Okay.
Take the abstract of title and advertise it in the newspaper.
Now, what would that wording be? I have no idea.
Well, if anybody's, I'm claiming legal ownership to the land described as, and put the description in there.
Right.
Anybody who has a claim to title and ownership of this land must bring forth the claim.
Right. Do I have to mention the bank involved or just anybody that has a claim?
Forget this bank. They don't own that property. You do. You just haven't claimed it.
That's right. Then I publish in the paper for how long?
Well, for 2 weeks.
Okay. And then you have to go to now I'm calling from Cleveland, a land court. Is that, would I go to probate court?
County court.
County court. Now,
go to a county court and file a petition.
And
for title. If you want a quiet title. You want a declaration of quiet title. There's forums on the internet for doing that.
Okay. You said one interesting thing. I think somebody had called earlier and they said, I don't know if it was their house or whatever, and when the sheriff's sale was there, well, I didn't go. My house went for sheriff's sale on November 22nd, and the bank bought it themselves, and you said something about there was no money exchange, I'm sure. There's
no, if you go into 2924, there was no, they're not the owner because they didn't pay for it. There was no bona fide purchaser for value.
Okay, I'm not familiar with these numbers. This 2924, are you referring to the Constitution, or what are you referring to?
California Civil Code.
Oh, California Civil Code. Would that be in the Ohio? Is that the same in Ohio, or do you know?
Oh, no, you'd have to go into the Ohio statutes that govern sale. Ohio is a judicial state.
Right.
Well, if they sold it, they have to sell it. They didn't sell it.
No, there was no money transpired, I'm sure.
Well, I don't think, I know there wasn't. I don't think there was.
Because like you said, it's supposed to be cash or certified check, and I'm sure that didn't happen.
It's all bogus.
So what can I do regarding that, regarding the sheriff's sale? Any type of filing?
Well, you have to do it. If you do a quiet title,
right,
then you're challenging their ownership of the land.
Okay, so basically, if I could just go over this real quick, I want to file the quiet title. I need a surveyor to do meets and land. Meets and bounds, I'm sorry, on the land regarding same thing as distance and direction. I want to do an abstract of title, publish it in the paper that I am the owner. Anyone out there who claims to have, any type of claim or ownership needs to come forward. And if 2 or 3 weeks go by and no one comes forward,
then you ask the court you want the court to issue you a declaratory judgment that you have title and ownership of the land.
So now in Ohio we have common pleas and we have federal courts. So I don't know all these different names of the courts. I mean, we have probate court, I know, but I don't know county court. We probably have the same thing, but we call it something else. Do you have any idea what it's called in Ohio?
You'd have to go look at
municipal court.
I'm sorry?
Justice court or municipal court.
Call them and say, where's the county court?
The county court, okay. I do want to mention one thing also, which I thought was really, really strange, because I've been doing this foreclosure for 4 years without an attorney, and there's a lot of fighting, and obviously, you hit the nail right on the head. I'm not presenting it right, not using the right wording, and the lawyers on the other side are having a field day knowing that I don't know. But my question to you is, how when you go to court and the judge would say, okay, we'll accept copies of a promissory note, we'll accept copies of blah, 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 and a lot of times judges just throw things out that someone like me presents. I mean, how is that allowed? How is that legal?
Well, did you deny the authenticity of the signature?
Absolutely.
They have to produce under 3308 and the best evidence rule. 901, 902, 903. In Ohio, go get your state evidence code.
Right. For some reason, like I said, it's because this case has been ongoing for as long as it has, I have submitted motion on top of motion. They're all denied. I have never had a motion granted.
Okay, but what are you alleging in your motion?
Well, basically that that they have committed fraud. That there was no loan actually. When I signed the loan in the very not the loan for the money, nobody else signed that paperwork but myself. The bank.
Did you ask the judge to make them prove up where the source of the funds was under the Patriot Act?
I didn't say that. I started with a couple years ago with produce a note.
Did you know that all these courts are under the War Powers Act?
I don't know what that is.
Well, the HCR 192.
What's that?
The Emergency Bank Act of June 5th, 1933.
So, which means they don't have to come up with this paperwork?
What do you think?
Absolutely, because in Ohio, I can't speak for anybody else, and I think there was a gentleman caller that called before. I mean, we're listening to people, educated like yourself and Angela, and trying to get, this expert advice, but they just slam us crazy and just deny it. And in fact, I got one report back directly from the judge that said the defendant, which was me, continues to demean and delay the proceedings of this court, and further action on her part will not be tolerated. She said that to me on my docket.
Okay, was there a yellow fringe flag in the courtroom?
I don't think there was any flag. It wasn't like a trial, it was a hearing. It was just like there was the judge, me.
Next time you go into court, look at the flag. What kind of flag they got?
What does the yellow one mean?
The military flag.
The military flag.
Yeah, tell them that they didn't. There's no proof on the record that they funded the note and that the note was secured.
I don't know why it seems as because I've talked to many people just from going to the library on the internet and so forth. Ohio is just a pro-bank state and pro-lawyer state, and it's we as individuals that
I won a foreclosure case in Ohio.
Did you?
Yeah.
Well,
in Powell. You know where Powell is? Powell, Ohio?
No.
It's on the outskirts of Columbus.
I live in Cleveland, like northeastern Ohio. So that's about 2 hours from where I live. But so how did yours? I mean, what was your complaint? Was it fraud, or how did you title yours? When you claim, did you countersue them against the foreclosure?
Well, I mean, they couldn't produce the note.
Well,
I got it thrown out twice. The first time they threw it out, the judge ordered them to produce the note, and they didn't produce it.
The judge said to me, because here was one of her comments, that there was a title search done by the opposing side from a subsidiary title company that the lawyers own. Because of that recent survey, she believes they are, in fact, the true parties of interest. And I thought to myself, the lawyers got their own title firm during the title search, and the judge says, yep.
Did you ask them for the abstract of title?
Because that should be in the paperwork?
Yeah, the abstract of title will show who owns the property. It will show you own it.
Exactly. And so how could the judge make this? I'm just thinking, how could she lie and say, oh, yeah, that's good.
Presumption.
Pardon me?
She created a presumption and you didn't rebut it. What does 1-208 say? The trier of the facts shall presume the fact to exist unless evidence is put into the record to show a contrary finding. You didn't rebut the presumption.
I did that. I didn't know. I don't have the knowledge that you have, believe me. I mean, and like I said, there was the sheriff's sale November 22nd. What type of motion could I do regarding...
Do a void judgment.
A what?
A motion for void judgment.
I tried that about 2 or 3 times, and it got thrown out every time. In fact, because I was in the common pleas in Cleveland, I decided to take it out of there and take it to federal court. And those judges there had a field day with it and remanded it back to common pleas because they said the case was intertwined and that they would not more or less go against the lower court, if you know what I'm saying. I don't know if that makes any sense to you or not. So I don't know, every time I get somewhere and I get near the goalpost, they just move it. Do you know what I'm saying? And when I know a little bit and they get not worried, but it's like they invent the law as they go. And because I don't know the law or I don't know enough to question it, like you said, I'm afraid of losing my home. And I definitely want to do the quiet title. I think that will help with a lot. I mean, do you think that'll cure a lot for me?
Yes. Yes.
All right. What do you think? What will it do as far as the foreclosure? Will it just come to a standstill?
Well, yeah. If you own the land, they can't take it from you, can they?
So what? And when they foreclose, what are they foreclosing on? My house as a fixture?
Yeah.
The building.
Property.
The house, not the land.
Right.
The land.
Oh my goodness. The book that you keep talking about, Zero Limits. Who's the author of that book?
Dr. Hugh Lynn.
How do you spell his last name?
How do you spell what?
His last name?
I think it's L. Well, let me.
Oh, I could look it up. You don't have to.
Well, no, I don't mind.
Oh. You must take really good vitamins. I don't know how you keep it up. I mean, you are really enthusiastic and you seem very passionate about what you do. From the way that you talk, it's very good to hear someone that is very confident about a subject they know so much about. And good for people like me and people like other callers that aren't sure. And are we afraid of these people? We shouldn't be, but they are very intimidating. You know what I mean?
I've had them parachute out the window. I've had them run out of the courtroom. H-E-W-L-E-N.
H-E-W-L-E-N, okay.
And Joe Vitale, V-I-T-A-L-E. You can buy it from Amazon. It's $15 from Amazon.
Now, who's Joe Vitale?
Yeah, Joe Vitale.
Is the author?
Yes.
Oh, I thought you said it was Hugh something.
Well, it's Joe Vitale and Hugh Land.
Oh, together. Oh, okay. Are there any books that you have out there that we could read?
Yeah. You got about 10 hours?
No, just something kind of like, like little Main Street, little one person like me could read and not have a migraine when they're done. Can you narrow that down a little bit?
Oh, are you talking about legal books, or are you talking about
foreclosure and what you can and should do and what they don't want you to know?
Yeah, here's a book. Let me find it here.
If it looks like an encyclopedia, that'll make me nuts. So.
No, it's let me hang on a minute. I'll find it.
Okay. This poor guy. Sorry for him.
Come on, Gene. You're supposed to have that stuff at the ready.
That letter that he wrote, that lady that called from New Jersey or whatever, and that letter that he wrote, oh, my God, he sounded like he was a federal prosecutor. That letter was, I'd get a little letter like that, and I'd forget whatever I was doing, too.
Yeah, well, but we all can't write letters like that.
I couldn't write one-page letter like that.
You have a lot of learning to do.
And I am. Believe me, the last 4 years being in and out of court and I think they think I'm less of a person because I can't afford an attorney and legal aid is not helping at all.
Oh, listen, you don't care what they think.
Now? Oh, you know what I do now? Because they think the intimidation is much over with as far as I'm concerned. I take a briefcase and I don't have anything in it, and I just bring it to look like I'm an attorney.
Okay, here's the book.
Okay.
Here's the name of it. The Law and Practice as to Probate, Administration, and Guardianship in the Surrogate Courts.
Oh, gotta go slower. I'm sorry, Gene. The law, that's all I have.
Well, let me type in Alfred Howell.
I don't have a computer. I'm a grandmother that does not have a computer. I'm sorry. So I'm writing this down.
Hang on just a second, okay?
Okay.
I think he left the room.
I don't blame him.
The law and practice. What?
That's about all I got.
Yeah.
Why are we not hearing very much about foreclosure anymore, like in the newspaper or President Obama? Why is it like been sidestepped?
I don't know. I don't pay attention to the news. I'm on the internet, so I'm getting it every day.
Yeah.
So I don't see it not.
This book has to do with probate law. It's an old book.
Okay, the law and practice, that's all I have.
Okay, well, let me see if I can find a shorter title for it.
Thank you.
Bought it off of Amazon.
So this will kind of tell you the do's and don'ts of foreclosure and things they don't want you to know?
Well, you need to understand probate. That's why you guys aren't winning in court.
You got that right. I will tell you without a doubt in my mind, in Ohio, when you say produce the note, they just about laugh you right out of court. I mean, that is almost hilarious to the judges and lawyers. Nobody
Tell them to produce the loan.
Pardon me?
Tell them to produce the loan. Tell them you never got the loan. Show me your books and records showing me where you paid me any money.
Where the security is.
where the security note is?
Yeah, ask them where the security is.
Well, they showed me a photostatic copy, and the judge said that was good enough.
No, it's not. You should have said, I object.
I should have.
If that's the case, then here's a photostatic copy of my house. Let's trade.
I should give them photostatic copies of, or no, just monopoly money and say, here's the $84,000 I owe you.
There you go.
You should retype your deed of trust and say, I got the original note. Retype your note and endorse it and bring it in there. And say, here's the original note.
Oh, I'd be on TV. I'd be on Oprah.
Say, I got the original note, Your Honor, right here. Hold her in due course.
Oh, I think I'd be in jail.
Why? It's your word against theirs. They're going to pull out. They're going to bring you a Photoshop copy.
Yeah, they have done. Oh, there's a lot of forgery.
It's already been proven. It's in the court cases already.
I know. I've heard of Judge Shack in New York. I don't know if you've heard his name.
Right. Sure, I have.
He's done some major damage as far as banks bringing, phony baloney information forward.
I think he coined the phrase robo-signer.
Yep. He most certainly did. So I've been following him quite a bit in the Kansas City landmark case, and hope these attorney generals get together a lot better than they are.
Okay,
I work for the banks.
The law and practice as to probate.
The law and practice as to probate.
Administration and guardianship.
Okay.
In the surrogate courts.
How do you spell surrogate?
surrogate.
In the surrogate courts?
Courts in common form.
In common form.
And contentious business.
Hold on. Okay, I lost you after common form. What was next?
And contentious. COTENTIOUS.
Contentious, okay.
Business. That should bring it up. It's by Alfred Howell, HOWELL.
Okay. So this is the book I'm looking for, and I should have probably read 4 years ago?
Yeah, 100 years ago.
I hear you. Okay. Well, I don't want to keep it. I want to tell you how much I appreciate your help and your advice, and I think a lot more people are starting to get educated, and it's just not an easy thing to do for someone that is not as well-versed as you are. Do you know what I mean? Being that you're an expert and you know how to word these letters and attach these memorandums, and we go into the court and they think, oh, pro se, here's another one clogging up our system. That's the air we walk into. That's the environment that we're in, which is tough. But we are fighting back. So hopefully, people like you, thank you and bless both of you for all your help. And I'll just, I'll hang up and just listen to the rest of your callers.
Okay, great. Thank you so much.
Thank you.
Thank you. Okay, Sir Ryan, go ahead.
Hey, can you hear me?
Yes, we can.
Hey, how's it going, Gene? How's it going, Angela?
It's great. Thank you. How's it going with you?
Everything's good. Gene, I got a question for you. I have a situation with ID theft where my social security number was used to get a cell phone account open with AT&T. And what happened was I called them. They told me to get a police report. I did that. And they ruled it to be fraud. But I checked my credit report, and it's a third-party debt collector. And it's still on my credit report with that third-party debt collector. So, I'm trying to see what all laws are they breaking, and, what all laws are they breaking, and what charges can I bring? If I wanted to make a letter,
You mean somebody else used your social security number?
Yeah. Well, it was a friend of mine. Well, a former friend of mine.
Okay.
Is it anything I can send to the credit bureaus also? What laws are they breaking?
Well, they shouldn't be putting that on your credit report.
like I say, the original credit rules that it's being fraud. I have paperwork where they sent to my house where they waived it as being fraud. You know.
Well, you ought to make them take it off. Write them a letter and make them take it off.
What should I put in a letter? Should I file with the FDIC also? A report saying this is fraud and.
No, I'd file it with the. Is that something they put? Do they do it on a credit card or how they do it?
Well, I think they did it over the phone. You know how you cell phone companies may send you something in the mail. Well, see, this is what happened. I was supposed to be renting with the guy, and the light bill was in my name. In some kind of way, he got my Social Security number.
So did he use it? But if you can't buy something using a Social Security number. You got to use a credit card.
I don't know how he charged it, but when I checked my credit report, it was in his name. I didn't know anything about it because I'm trying to buy a house, and I can't buy a house right now because I'm in this situation with this ID theft situation.
What you need to do is write a letter to the credit card company and tell them you want or whoever's charging you that and make them take it off.
I mean, you mean the third party debt collector?
Yeah. Or you're going to sue them.
What laws are they breaking?
Well, they're committing fraud. It's not your...
defamation of character? I mean, what?
Yes, defamation of character, unauthorized use of your number. I'd make them take it off your credit report.
I tried it. I called out of the credit bureau. They said that the company
call your congressman. Who's your local congressman?
Mississippi, I don't know.
Find out who it is. Go to them and tell them you got a problem. And tell them who the debt collector is. Tell them they're using your Social Security number without your authorization. Watch what happens.
I mean, because they don't even have a valid contract with my signature. How they're breaking that rule, right? They're breaking that law.
Yeah. The congressman will make them take it off. They'll listen to your congressman. I had a problem with my Social Security, and I called my congressman up. They called him up, and I had my problem was solved in one day. You're the sovereign. Act like one.
Yeah, you got to know how to talk to them too.
Yeah, that's what I'm saying. I want to send a letter like that letter you was reading earlier, Gene. You had a different law in every Senate.
You can do the same thing. All you got to do is just you got to work at it though. I didn't learn this overnight.
Yeah, it's a lot of studying. It's not something you can do in the next 24 hours. That's for sure.
Well, you got to
study.
You got to have a good command of the English language. You got to know legal terms, and you got to know commercial law. I know how to do a conditional acceptance for everyone I've done. It's been successful.
Okay.
That shows you if you know but you got to learn the law first before you can do it.
Yeah,
you got to make them prove the claim. They don't ever prove their claim. They never prove anything. That's why this quiet title on foreclosures will stop it. Because they can't prove that they own the property.
Yeah, this is the reason I can't buy a home. I would be in a home right now if it weren't for this.
Well, you're better off not doing it anyway. You're better off renting. That's all you're doing anyway.
Well, no, actually, I got to change the thought, Gene. What's that you said about just claiming a foreclosed house? So the person who had the mortgage left it up for claim or something? Was that an adverse claim?
They abandoned it, and I went in there and claimed it. I now own it.
Is that called an adverse claim or something?
No, I went in there and I did a hostile takeover.
A hostile takeover.
You ever see what a pit bull does to a chicken? You know what happens when a blowtorch it comes in contact with a paper asshole?
Okay.
You get spontaneous combustion.
Hey, let's see. I got another question for you.
People are too. They give up. You got to be tough.
Well, yeah, you got to know the law. Like I say, you literally got to have a different law in every sentence, like the one you read earlier.
Yeah, they back right down. Back them down. I've done it every time.
Yeah, that's why they back down from you. They know
I've done credit cards. I've done car loans. I've done every one of them's back down.
All righty, let's move it on here. Anything else, Sir Ryan?
Yeah, let me get one more question.
Okay.
Also, I want to learn. What should I learn about? I got a job with the city. I do IT, and I mean lately they just started taking a lot more money out of my check. You know, different things.
Are you on my Tuesday night classes?
No, but I will sign up.
Go sign up for it, and I go into this stuff. I'm going to go into this, how to do all this stuff this next Tuesday.
Should I file like an EIN number to get exempt from all taxes taken out of my check? Or do I have to? I don't have to go through all that.
File a W-8-BEN.
I mean, 'cause I filed when I did my W-4, I only did like one exemption, and I mean, they was taking the Fed by itself was taking like over 200 out of my check, and then once I did a W-4 again and tried to change it and put 3 exemptions on there, and the FDIC started taking out more, and the federal started taking out as much.
File a W-4 exempt. Or a W-8. File a W-8-BEN. They won't take any.
Go ahead. Say something, Gene.
W-8-BEN.
Okay. All right. That's all I have.
All righty. Well, thank you for calling, and we'll talk to you later.
I appreciate it.
Okay, Mission. Let's see here. Get this to unmute. There you go. Go ahead, Mission. Did you have a question for Gene Keating?
Hi.
Hi.
Oh, thank you. Hello. Yeah, I'm in foreclosure. I received a summons, and I did a motion to dismiss, and I think it worked. Now the bank is calling me. They want me to recontract. But my question basically is, that was just kind of the grounding for it. But they sent me a check, and they said, we're returning your check because it was less than the full amount due to bring your account current. I've never sent them a partial payment. And I don't know if I have any ramifications of going ahead and cashing this check or what. And then down at the bottom, a footnote says that this is an attempt to collect a debt.
Okay, they sent you a check? You mean a refund?
No, they said they sent a letter and they said, we are returning your check number, which is actually their check, not mine, for a certain amount because it was less than the full amount due to bring your account current. Unless prior arrangements have been made, only the full amount due will be accepted. Continuous delinquency is not acceptable.
Isn't that interesting?
And they've already sent me in foreclosure. You know, and I'm thinking, what are they up to? Are they, you know?
Yeah, it sounds like they're trying to get you to contract with them.
Right, and that's what I'm thinking. You know, I'm thinking, well, what happens if I cash this check? Because I have written him a letter saying, you know, to give me some clarification as to what this check is.
Do you have a copy of the letter?
Yeah.
Email it to me.
What's your email?
MICHNOWSKITOM@yahoo.com.
Okay, what do you want me to put in the subject line?
Letter.
Okay.
Just put your name in there.
All right. Yeah, because, you know, I'd like to cash this check, but I don't want to do it. I'm going to get all kinds of ramifications. I don't want to recontract with them.
Yeah, that's what it sounds like.
Because I've never sent them a partial payment ever. Especially.
Okay, so is that it?
That's it. Thank you very much.
Thank you. All righty, let's move on to California. Oops.
California, here I come, right back where I...
Oh, I'm unmuted now.
Hey, Dallas.
Hi, how are you, Angela?
Fine, thanks.
Before I ask Gene a question, I just need to take about 60 seconds to, I guess, just respond to, because I'm in California and you are too, to the one you call Mr. Doreener Sizzle. I kind of addressed that situation. I did what he said 11 years ago, and I stood there sovereign and everything else like that, with the attitude, the mentality, who works, and I got arrested. After being arrested, then I started using practical things like what Gene is talking about, and I haven't been arrested since. Still keeping that same mentality. It's not just the mentality, it's the practicality as well that needs to be used. So that's why being someone from California, I know you mentioned scripture. Hosea 4:6 says, "My people perish for lack of knowledge," and that's why we're learning when we call these calls. And the other one I'm using right now when I'm talking to Gene is Matthew 7:7, "Asking you shall receive." And that's the only way we learn. So I think it's a little bit of everything, not just one direction. I appreciate him, you know, and I know where he's coming from, but it takes a little bit of everything. My question to Gene, the first thing you already answered, Gene, because I want to know if you were where you were, what state you were in. You said California, and Rancho Cucamonga, which is about 15 minutes north of where I live. I'm in Riverside. And I will be on your Tuesday call, your Tuesday webinar. My situation is kind of an interesting one. I haven't filed or done an income tax return in 25 years. And over that time period, because of the statute of limitations, everything was just, it was removed because of the 10 years gone by. However, I didn't hear anyone speak of this, and I've been back and forth with the call because I'm a caregiver for my father, so I have to go and attend to him every now and then. But I didn't hear anyone ask this question regarding being in California, the Franchise Tax Board. That's one. The Internal Revenue Service, I don't have any issues with them other than the fact that this is the first year since 1981 I've ever received a W-2. And I want you to know how to do the income tax returns, which I'm sure I'll learn that when I get on your webinar.
Yeah, I'm going to go into Tuesday.
Right. I want to do it the right way. And that's why I mentioned on the last call that you were on last week that I've been hunting you down since I watched a video that I had from you last year. And now that I know where you are and you're just like 15 minutes up the road, that feels good. I want to know how to do the income tax return properly. However, with the Franchise Tax Board, what they told me, I'm about to, as a matter of fact, I don't know if they put it up there yet, but I'm about to have my name next to some of the ones on their website because it's gotten up that high. This is way back in the 1980s, in which they told me the IRS may have their statute of limitations, but ours never ends. If you owe it, you have to owe it for the rest of your life until you pay it. So how would, with the Franchise Tax Board, how would that, being that so old way back, would I need to do income tax returns, 1040s, and all the other forms that go with the IRS from those years in order to handle and eliminate the Franchise Tax Board?
It's predicated on the federal.
Correct. And I know you have to have the adjusted gross income to start the 540 on the Franchise Tax Board. That's the very first thing that goes on there.
Well, when you get rid of the federal, you'll get rid of the state.
Correct. So what I need to do, this is back in 88, 89, 90, and 91. So I need to go back there and do those with the IRS.
They only go 7 years.
Now, I've already spoken with that. You mentioned something about 7 years?
It's criminal is 7 years, and civil is 3 years, I think.
Okay, so you're saying, right, that's why they say, 3 years with the IRS. But this is back in the 80s and beginning 90s that the Franchise Tax Board is saying that they want me to do, and I keep telling them the IRS doesn't even have the records anymore. And I've already spoken with them. They don't even have the records anymore. They said it's 6 feet under, the bones are there, but everything else is gone. And they said, and they even told me with the IRS, if you want to pay it, you can. You can. We don't have any information on it. But the Franchise Tax Board is telling me, well, you're going to still owe it. Interest is accruing. Penalties are accruing. It's got to be somewhere around $150,000 or something like that right now. And
yeah, but it's piggybacked upon what the IRS says.
Well, the IRS says that I don't owe anything.
Well,
but the Franchise Tax Board won't hear that, so they keep sending. The last time they sent me the bill, they only send the bill once a year, and they sent me the bill. I did the acceptance for value the way we were doing it before, different than the way Gene is saying how to charge it back to them. Well, I didn't charge it back to them. I charged it back to the all capital letters name, and that I haven't heard from them, but I haven't called them yet. But and maybe I should call and find out. But I probably need to check with them and see if it's still there. But I don't usually hear from them for about a year, and then I'll get another letter from them. And it's been almost a year now. So being that it's so far back in years, and there's nothing I can get from the IRS. I have my old records. I have my old notice of federal tax liens from all of those years. I have the releases because I requested the releases from the IRS. I demanded that they send me the releases, the release forms, and they did, and send it to the county recorder's office to actually release it. And but the Franchise Tax Board, they're just a different nut to crack, and they just won't give up until I do an income tax return or something or pay it to get rid of it. So how would I do that if I can't get the information from the Internal Revenue Service for way back then?
I'll go into it Tuesday.
Okay, well, let me ask you one more question. How long, with all these things you're going into, how long is your webinar on Tuesday?
It's 3 hours. We went 3.5 last Tuesday.
Excellent. Okay, good. Okay, well, I have to download Skype onto my computer. I've already emailed Toby. They said I need to contact with Skype. I need to download it. I have a new computer. And so I'll download that and contact him.
I want to be registered before 4 o'clock on Tuesday.
I will be registered tomorrow.
Okay.
I get all of it done tomorrow. And
right.
Because I want to do this. I haven't, like I mentioned, I haven't done an income tax return in 25 years. And, and I know that it needs to be done. I know that the accounts need to be balanced. But everything I've heard so far just didn't make sense to me until I saw your video that I have last year. I just didn't know how to get in touch with you until, thank you, Angela, you had him on.
Oh, you're welcome. Thanks for coming on, Dallas. Okay, we're going to move along. Let's see here. Puzzleman. Go ahead, Puzzleman. Puzzleman?
You hear me?
Yeah.
Okay. I got a question. I did a couple of A for V's back in March, and one was for a credit card, one was for a vehicle loan. And I just today received a notice from the IRS, and it says that we've determined that the arguments you raised are frivolous and have no basis in law, and then it proceeds to say that if
you didn't file a return.
Pardon me?
You didn't file a return.
What return?
Have you been listening to the call?
Yeah.
You got to return the income back to the IRS so they can issue you a refund.
Well, they sent me a voucher, and down at the bottom on the voucher it says use for payments.
Yeah.
So
you didn't make the payment to the IRS so they can give you a credit for your credit they've been using.
So what form do I use?
Well, you got to use the 1040, 1096, 1040V, and you got to do a pay to the order of it. I'm going to go into that Tuesday night. Show you how to do it.
On Tuesday, I paid for last week. Now, each week you got to pay $25?
Yes.
Oh, because I'm real strapped on funds right now.
I'm going to go into it Tuesday night.
I don't have any internet service right now, so that's why I'm on my cell phone. Oh, golly. Well, maybe I can try and find some people that can help put together some funds for me and get on there.
Okay. Glad to have you.
I got one other question. Should I request the proper forms for them to send to me?
Yes. Most of them you can download, except the OID. You need the 1096 and the OID. The 1040 you can get from the internet.
Right. Okay, and then just hang on to this voucher until I fill out those papers?
Yes.
Okay.
I'll show you how to fill it out.
All right. Well, that's all I have to say. And thank you, Angela, for getting me on, and thank you, Gene, and for all the good work you're doing and helping everybody. And Merry Christmas.
You're welcome.
God bless you. Thank you.
Thank you.
God bless everybody. I love our group of people that listen and want to learn all this stuff.
Yeah, isn't it wonderful?
Yes.
Hey.
Go ahead, California. Did you have a question? Oops. Go ahead, California. I hear you moving around there. Oops. Hi, California. Say something. Did you want to ask Gene a question? I hear you. Did you want to ask Gene a question?
Big now or forever hold your peace.
Yeah, really. Guys got to learn how to use your phones. I don't know. Okay, we're going to move on, California. It looks like you're trying to come on the call, but...
how many more people we got?
We've got 5 more questions.
Okay.
Is that it?
California, is that you? Go ahead.
Okay, I had too many mutes on.
Yeah.
Yours and the star 6, the other one.
Okay.
You had a lot of questions for Gene, actually. How would you apply some of this, like say, there's so many people that have been following all these things for so long and they're always just behind the curve. How would you apply some of this to someone who's already lost their home and a while back?
Take it back.
2 years, like
house.
Year and a half, something like that?
Yeah. You haven't lost it yet.
Well,
you lose when you give up.
Well, no, I haven't given up. That's why I'm here. But it seems like every time, there's a lot more remedies now out, of course. But every time you're at something, it's like tonight. Everything you're saying, oh, you're still in your house. You do this, you do that. How would you apply quiet title to that? To someone that's already out of their house, and they've already sold it too. But of course, the person bought it without warranty, right?
Yeah. Do the quiet title. Don't worry about the
all right, then how's the enforcement? Like, for example, you said you'd done this letter 8 months ago in the place you're at in Rancho Cucamonga, and then, what, you've done nothing now? I mean, what have you done? You haven't heard from them in 8 months, but...
they're not going to do anything. They don't own the land. They don't have any authority to do anything. I backed them. You start a fight with me, you better ready to get down, brother.
Well, I understand all that, brother, but I mean, like, so what are you going to just, like, let it set at that? Not hearing from them, and so you don't want to record it again. That puts it back in their jurisdiction. But how do you?
I own the property.
Yeah.
I own it. I don't have to prove it to anybody. If they try to come after me, I'll do a quiet title.
Okay.
Right now, I'm trying to help other people.
Okay, so a quiet title would be what someone would do who's already lost their place and been put out with the course and all these things that are a lot of them. I or many people have already done in court. They just go right over the top of a lot of it, objections or no objections.
You're not. You do it right, you'll get your remedy.
Yeah, I understand that, but there are some, and many times I don't want to talk about those because that's like acknowledging the negative. So the only thing is a quiet title that you would suggest for someone who's been already put out. Do that, and then what would be your next procedure? What would be your next step after you've done that?
Tell me what you want to move in. Move into your house.
Yeah.
I have a brother who's a judge here in California.
Uh-huh.
He says I'm absolutely right, 100% right.
Oh, we all know we're right, but it's getting the enforcement, the remedy, isn't it?
Well, yeah.
So who do I tell that I want to move in the house? People that are there, or the mailman when he drives by, or the judge, or they're the ones that, well, whatever.
You ask for a writ of possession. Do an unlawful detainer. How'd they get you out?
Well, they did it while I was gone. It's called commandeering and all kinds of other things. And then it was like if I knew, I can't tell you how many times me and many of us, over the past year and a half, if we knew what we knew last week or last month or today 2 months ago, or just it's always been like this $1 late, penny late, $1 short, or day late, penny short, however that works. But it's there's a lot of incredible stuff that's coming out, but that's too late for me. That's too late for me. And I know I can do that, like you said, but then all of the procedures, it seems like you're still jumping into their contract, their permission, asking them, so to speak.
What do you want to do? You want to go over there and just take it over? Brutus?
Brutus, yeah. Well, if they'd get up the tree, I'd give that a shot. Well, what do you suggest?
Well, you got to don't focus on what you don't want. Focus on what you want. Well, you want your house.
Absolutely.
Go after it.
Well, that's what I've been doing.
Yeah, I do a quiet title on the property. Get the title cleared and move in there. Tell them you want the house back. Do a writ of possession. If they won't move out, do an unlawful detainer on them.
So the people that are in there, you say?
Yeah.
Yeah. I don't believe they even paid for it because there was all these stages that the sales of homes went through. Where there for a long time the banks weren't selling their homes, and then the ones that were being sold, it took several months. And this guy was, when they finally fraudulently got rid of my list pendants and all this other stuff, it was like done in 2 weeks, and the paperwork went everywhere, from the notary that signed it was in Colorado, and here it's in California. And,
they don't own the property.
No, of course not.
They're
I don't even think they paid money for it. I think they were in the cahoots with the realtor, who also came into court and perjured themselves and said that they were the bank representative from the bank, and it wasn't a bank; it was a trust company. I mean, they erased all of the transcripts and the records that I said. It made me sound like I was Spanish almost, because everything had been taken out. Which is what they do. All the objections and everything I made throughout, everything was gone and erased and deleted. But that's what you're dealing with. They're doing whatever they can, whatever they want, as much as you want to do everything right and go along these proceedings. Do some more cleaning, right?
Yeah.
Clean, brother. Watch what happens.
Yeah, I'm gonna do it. Tried everything else and I haven't stopped.
Yeah, be persistent. John Stewart talks of a woman that went into court. This was after her house was sold, right. But there was something about the lawyers. They were back in the courtroom, and she kept saying, have them stipulate as to being the creditor.
Right.
And that, and they kept rolling over her and not talking about it. On the fifth time she said it, the judge looked over to the lawyer's desk and said, "Can you stipulate to being the creditor?" And she got her house back. Yeah. They couldn't. On the fifth time.
Well, I was in there for 45 minutes objecting to everything. That one piece of paper I said is a copy, and that's a forgery. And I goes, but that's beside the fact, because we haven't dealt with the part that I've objected to in the beginning, that this lawyer, he wouldn't even give me his ID. He's not the attorney, in fact. And and then you're allowing him to testify, and you're testifying. I mean, that was just, I objected to everything, and they just kept on going.
The court is abating and abetting the banks to steal my property.
Exactly.
Put it on the record. Say it on the record.
But it didn't come out when you get the recording, and I had to fight for that, like almost screaming 2 weeks later for the appeal. I had something in the other department for the counterclaim, and they went over everything. I won that by default, and another law firm came in and
make the judge the executor of your estate as the donor.
And I did administrative proceeding. Make him the executor of the state.
Yeah.
And
watch what happens.
Well, they're never closed, correct? Is that right? These cases. I mean, it's been a year and a half. So now I just finished a forever administrative process because I wasn't getting any results there. Because they really beat you up. You're so broke. I mean, from where I was before to what this is the scenario they have with everybody. I'm not anything unique. But, you're saving even money for stamps to make your certified or registered mail thing. And so I just finished that. And
you know why they're on you?
Why? Because I keep going.
Because they know you don't know what you're doing. They don't beat up on me.
Well, I mean, everything that they beat up on me on, yes, I didn't know what I was doing then. But, you learn that one now, but that's too late,
Scriptures say, know the truth, and the truth will set you free.
Yeah, I've heard that.
They're probating your estate. You have to understand that.
Yeah, that's one I just learned lately with, Angela having David on, certainly.
Yeah, when you know probate law, you can make these people run from you. They ran out of the courtroom. I made 2 judges and 4 DAs run out of the courtroom. They shut the courtroom down and dismissed the case.
And this is because you filed the paperwork that made them fiduciaries
I did a complex trust under California probate code. And I made them the executors and administrators of the estate. And they had to pay all the taxes or dismiss the case, so they dismissed the case. They ran out of the courtroom. I'm not trying to be dramatic. I'm telling you what they did. And the guy that told me this was the guy that we had a professional process server serve the papers. They ran out of the courtroom. They didn't walk, they ran. Can you see a judge with a robe on running down the sidewalk?
Yeah. It's a nice, everyone would like to see that look. You got video?
So hard I almost fell off my chair.
Yeah.
He told them, he says, if you don't tell me who did this trust for you, I will put you in a mental institution. He wouldn't tell them. So the judge dismissed the case. know what was going to happen. They were going to fly me out there to confront me, and I was going to go. But the judge, they gave up. They sent up the white flag. They actually hired attorneys. The judges hired attorneys to try to get out of this. If you want to know if this works, they hired attorneys. I'm not making this up. I can give you the number. Somebody will tell you that's what they did. They hired attorneys and tried to get out of this, but they couldn't get out of it.
Did the attorneys even take it, or they just refused to take it?
Well, they couldn't do anything because of the power of appointment. Because I know what I'm doing. Powerful stuff when you know what you're doing. I know what I'm doing. I know I'm right. I don't think I'm right. I know I'm right. You know the
Where do you go to get oaths of office?
I mean, I've been doing this for years now.
Yeah.
I've been successful on every one I've done.
So where do you go to get the oaths of office?
What you're doing. If you know what you're doing, they just.
Yeah.
They sent up the white flag.
Yeah.
But you got to know what you're doing. Don't make it. It's not all that difficult. It just takes a little study.
Well, I've been doing a lot of study.
Well, you got to study the right material.
Of course. Of course.
You gotta learn trust law, commercial law, tax law, and accounting, and you'll have it down pat.
Okay.
You can make them run out of the courtroom.
Well, I just rather make things right. I'm not much in making people
Drama.
do tricks. Yeah, drama. Yeah.
Oh yeah, that's just
undone.
Happened as a result of that. I thought it was pretty funny. I can just picture judges running out the courtroom. I think that's funny. That's the funniest thing I've ever heard of.
All right. What's all that noise?
Yeah, really.
Somebody's making racket. Is that it for you, California?
How could I ask them? How does this? Would you apply this like to banks or for checking account, for example? You don't do quiet title there.
You mean who owns the checking account?
Yeah, or yeah, exactly. Or the way they're monetizing than what has been disclosed.
I'd close the account, close count and check. Electronic transfers.
And then can you go for, that's what they did to me. I think it's because of the OIDs I did for the past 4 years, but they closed the account after having it 20-some years. And then, trying to charge me for charges they put on and off kind of a thing. So I did a conditional acceptance, negative averment, and they just went silent, and that cured also. But
you didn't do a conditional acceptance right. I haven't seen one conditional acceptance that's been done right. Not one. The wording isn't right. You're not really doing a conditional acceptance. People think that all they have to do is write, I conditionally accept your offer on proof of claim. I make them present the instrument. I make them produce the authority for making the presentment. I make them prove that the debt, there's no accord or satisfaction of the debt. I can prove that it's paid.
I kind of went through that. I did an affidavit with about 10 points. I mean, I don't have it here in front of me, but showing that, having them present that they were the source of the funds and provide the 1099s, the OIDs, and then I went on to say,
you got to do it under the Patriot Act because they're under the War Powers Act. The court is. That's why they're not making. The courts are operating under the War Powers Act.
Well, this wasn't done in a court. This was done administratively through the my court on paper in the mail.
Yeah, but you use the War Powers Act. Watch what
The
happens.
War Powers Act. Okay. All right. So I didn't put any of that in there. You're right.
Title 31, Section 5311. Title 31, Section 5311, and 31 CFR 103.11 of the Code of Federal Regulations, Treasury Regulations.
Mm-hmm.
That regulates the bank. It's called the Bank Secrecy Act. It's 31 USC 5311 et seq.
Now I heard you doing some stuff in that letter you read in court of record. None of these.
Yeah, they that shut them right down. The judge,
but
the calendar.
But none of these, like the laws and statutes and title this and that, fall under common law, do they? That's their statute law, isn't it?
Well, when you do it privately, you're under common law. That's why I don't record it with the clerk. I go into the judge. I make a contract with the judge, and then I run the court.
Right.
But the court of record is for. Go read your Constitution.
Yeah, I've studied there too. I've studied.
Hey, Article 6, Section 1 says this is a court of record. Well, it's for sovereign.
And the others are inferior courts, right?
Yeah, I told him I was a sovereign and a posterity and a heir and a beneficiary to the Constitutional Trust. And he had an obligation by oath of office. You got to read it. I wrote this to a federal judge.
Where are their oaths? That's what I asked you before. Where do you get their oaths? It's hard to find them anywhere.
Well, federal judges don't have it. They have an oath, but it's with the IMF fund.
Right, because it's their contract, probably. What about the Superior Court judges? Where are theirs?
They usually file them either with the clerk or with the Secretary of State. Ask them.
Yeah, you do, and they don't give them to you. You go to risk management, to the Secretary of State, you go to the Supreme Court and start looking up, under their bar number. You go everywhere, but you can't find them. You're always saying you get them, but where?
Well,
have you gotten them in this state yet, or have you looked yet?
Give me a judge's name, and I'll get his oath.
All right. Okay. I got a list of 5. They played football with me in lateral from this one to that one to the other. And the same thing with the law firms. It's ridiculous in this case.
I'm cut to the chase.
Yeah.
Okay.
But I don't think it's all right. Well, let me get off so let someone else ask. But
we're in the 4th hour.
Along. Yeah, exactly.
Yeah, moving right along.
Yeah, moving right along.
Okay.
Thanks, Gene. Angela.
Thank you. Okay. Trust law. Hey, Carlos. Do you have a question for Gene Keating?
Yes. Hi, Dan. Hi, Dan. I know you already talked about this, Gene. Could you rephrase? Have a huge property tax bill, and it was due December 6th. It's a little over $6,000. How would you approach it?
I would do a pay order on it. Are you on my classes Tuesday night? I'm going to go in all this Tuesday night.
Yes, I am on your class. I was on the last class. That was my first time. I really enjoyed it.
Okay.
Okay.
I'll show you Tuesday night how to do it.
Okay. And last question: what is it that we can ask the bank? I know they're not going to bring it or supply it. What is that we can ask so that we can prove them that they've been paid or that
the abstract of title.
The abstract of title. Okay. All right.
It'll show that the loan was paid off at closing.
Okay. The abstract of title. Okay. Thank you.
You're welcome.
Okay. Thanks, Carlos.
Thank you, honey.
Okay, moving right along. Northeast Indiana. Hey, Northeast Indiana.
Hello?
Hello.
Hello.
Okay.
Hello.
Can you hear me?
Where's that? I can hear you. Go ahead.
We can't hear you now, Northeast Indiana. You did something. I don't know what, but we heard you fine the first time. Now we can't hear you. I don't know what you did.
Can you hear me now?
Yeah, we can hear you now.
I've had the same problem the other gentleman had finding the oaths, and I've been passed around. And when I did find the oaths with the clerk or with the recorder's office, they didn't have commissioning papers with them, and only the prosecutor had a bond. Not one of the judges had a bond, which in Indiana law it says that the office is vacant. But I can't get the newspaper to publish anything about it. They don't want to hear that.
Do a writ of quo.
Pardon me?
Do a writ of quo warranto.
Okay.
Get him removed from the bench.
And the reason why I was trying to get their oaths was because a friend of mine has been locked up. It'll be Tuesday. He goes back to court, and we had filed papers that showed they've committed fraud, and now they're trying to find him incompetent. Every time he's fired the public pretender, they've reappointed him immediately. And I think the reason they're trying to find him incompetent is because now that we're getting down to the nitty-gritty to show that they've done this illegal activity and they're not holding their offices according to state law, statute that they're under, if they don't get it so he can't testify in federal court, they walk free. And I don't know how to put a stop to it before federal or before, Tuesday's hearing, when the public pretender was the guy who said, Your Honor, I think we should find him incompetent. And the judge said, by all means, can you have them papers ready in 2 weeks?
You know why he's incompetent? Because he's not the beneficiary of the estate.
Okay. And this is all over a unsafe lane movement where he stated UCC 1-308 immediately when he was pulled over, refused to give him ID, and then when they finally figured out who he was, they said, well, you don't have a driver's license. He said, yeah. He told him in court on the record, bring forth the contract that compels me to perform. They rolled right over that. They didn't want to hear that. Then he was going to say it 3 times. He said, is there anyone here in the courtroom today that has a claim against me? Come forward to be sworn in and state the nature of your claim, physical, financial, or emotional. And he started on it the second time, and the judge shut him down. And then the other time he was brought before the different judge, a woman judge, she said, state your name for the record. And he refused to give him his name, so she says, you don't give me your name, I'm going to find you in contempt. He said, would that be criminal or civil? She said, criminal. And he said, well, who makes the claim and what law has been broken? And she said, I'm making the claim, and it's court process and protocol that's being broken. And she slammed him with 30 days. And he's still, he's still locked up, and we're just afraid now they're going to try and find him incompetent. So if he needs to appoint the judge as an executor, you say?
Yeah.
But can he do that when he doesn't have that complex trust setup that you were talking about?
Yeah, he can do it orally. Go read the Uniform Trust Code. 407 and 406, you can do an oral trust. Make the judge the executor. Don't shut him up. Tell him I'm the beneficiary and heir to the estate of the decedent.
Okay.
Make them file their 1099 OID. To show they got a claim. Ask them if they paid the tax on there. Do a, you know what a margin call is?
Well, I know that the puts and the calls are how they're running the people through their court and making the money, but I don't know how technically to have him address the court for a margin call. No.
Okay, there. What if you do a margin call by making them file a 1099 OID to show they got it.
And that shows, because see, he asked for anyone to come forward with a lawful claim, and they didn't want to hear that because they don't have a lawful claim. They just got a fraudulent claim in the fiction name of the state of Indiana. That was the other thing. When we pulled the chronological case summary docket for the case, supposedly Indiana State filed appearance papers on the 16th of August. So I said to the clerk, I want a copy of the appearance papers. And she couldn't find it in the file. And she said, well, they hardly ever do that. They just started doing that lately. I said, well, you gave me an attested true copy here of a chronological case summary, and it's here. I want to see the file. And I want a copy of it because she said, well, why do you need a copy of that? And I said, well, because it'll have the bond number of the prosecutor on it or the deputy prosecutor, and I need that.
You know what an options contract is?
I guess if you had paid money up front for a chance to make money down the road on a future.
A call is an option contract to buy. A put is an option contract to sell. When you ask them for the 1099 OID, you're doing a margin call. If they don't put the money up, they got to release you. They're using him as the collateral for the options contract.
And so he needs to go in, appoint the judge as an executor.
Yeah, make the judge the executor of the estate, and tell him that he's the beneficiary, the heir and the beneficiary.
To the decedent, which is the all caps name they've charged.
They've charged.
And I appoint you, Your Honor, as executor.
And you got to pay the capital transfer tax on the put and call. Tell him I'm trying to do a margin call. You want them to file the 1099 OID to show the source of the funds for the charge. They claim they got a charge on him. They don't have a charge on him.
Right. Because they have no sworn affidavit by a real party of interest that's been damaged.
No, it's not. That's common law. They got to put a bond up, which means when you do a option contract, you got to have the funds up front, or you have to put a bond up. Otherwise, it's a private public debt instrument under 141 of Title 26.
So he's their bond. He's their surety that they put up.
They're using him as the funds. That's the collateral for the call, the margin call. He needs to do a margin call. Watch how fast that judge. You want to see a judge go from a tiger to a pussycat?
Yeah. So just have him on the record state, I'm doing a margin call. I appoint you executor, Your Honor.
And I want you to file a 1099 OID showing the source of the funds for your charge.
For your charge or for the charge being brought?
Well, what's the source of her funds for the charge?
But what I'm saying to you is,
tell the judge if she doesn't file it, you're going to do it, and you're going to have the IRS come out here and arrest her because she's a tax protester in possession of contraband.
Great. Okay.
Watch her change.
Well, I'm going to go to the UCC 406 and 407 and read that up good and try and get that information to him. If I get it out in the mail tomorrow, he should have it by Monday to read it over before court on Tuesday morning then.
Let me know what happens.
Yeah,
okay.
Let us all know.
Okay, I'd be glad to do that. Thank you so much, Gene, for all you do for us, and Angela for putting people like that on that can help us.
Oh, my pleasure.
You're my pleasure. We love you.
Okay, have a great day and a very Merry Christmas.
You too.
Thank you. Okay, we're going to move along here. Buddy 2010. Buddy T 2010. Go ahead.
Oh my God! I can't believe I'm on. I
can't either.
I listened to the David Clarence and the thing that you guys had done regarding the executor estate thing, and I saw some controversy within that. Gene, what is your controversy within the executor estate and occupying the office of the executor estate?
Well, actually it's the donor that runs it because of he's the holder of the power of attorney under tax law. The executor, the judge is already acting as an executor because there's no beneficiary or heir to the estate. So he does a constructive trust in equity, makes you the trustee, and appoints the plaintiff as the beneficiary.
But if you assume the role of executor, okay, the office of executor and adjourn certain matters, don't you have the ability to have the courts not do anything any further?
Well, I've done that. The heir and the beneficiary can do that. I made him run out of the court. I made the judge the executor of the estate.
All right. The reason I ask this is I have a property that has gone through summary judgment, and I'm in the process right now of waiting for somebody to knock on the door. So what would I file? What would I do in order to stave this off?
Okay, what do you have? Are they selling your property?
Well, I'm in Florida, so I'm in a judicial state. It's gone through the nonsense of somebody as trustee for somebody is, and there's been no real money transferred. So what would you recommend I do?
What, are they trying to sell your property?
It's already been sold, Gene. It's already been sold. My property shows as U.S. Bank as trustee for some nonsense.
They didn't sell your property. You're assuming that.
Okay.
You got to claim to do a quiet title. Were you listening to when I
I have been listening.
Okay, what you do is get the meets and boundaries description.
But are you saying that everything that Clarence professes is nonsense?
Well, let me ask you a question. Let me answer your question with a question.
Okay.
Has anybody done one of these executive letters and been successful with it?
Yes. I mean, there have been professions of success, but I don't know if it's the ultimate staving off of everything else. I mean, there have been professions of it. I have read them, I've seen them, and of course, that's That's evidence only based upon what's been put on the internet.
What does an executor do? What's his job, an executor?
Well, my assumption is, and I say this in all reality, assumption is you're the executor of the estate for your birth trust, if I'm correct, and that nobody else has any ability to do anything against you because you are the executor of that trust, and everything needs to be done because you are basically on a higher level of court than the lower level that issued the summary judgment.
Well, the judge is acting as an executor.
That I understand. But if I assume the office of executor, am I not in the realm of probate?
Yeah.
So if I'm in the realm of probate and I send it to the administrator of courts to dissolve this issue because it's adjourned and they had no for I don't want to raise arguments, but for the lack of terms that every one of these abandoned pieces of paper that they sent to me was nonsense to begin with.
Okay, but that's true. The executor does have that power. But the executor has to pay all the taxes, too.
Well, how can the executor pay a tax on something that didn't exist in the first place?
Go read 2002.
Go
read 2002 of Title 26. The executor has to pay the taxes.
So I'm better.
All this stuff is a tax issue. David's right. The executor runs the estate.
Okay.
But the executor has to pay all the taxes. Go read 2002 of Title 26. And if there's a taxable termination done, the trustee has to pay the tax. If you make the judge the executor and the trustee, he's got to pay both taxes. He's got to pay the tax on the estate side, plus he has to pay the transfer tax on the trustee side.
So what if I'm the executor and I name the county or the court administrator as the trustee? Does that not put that court administrator into a constructive trust?
Well, yeah, but it's not the who has the power of appointment? It's the donor has the power of appointment.
So it's a matter of
on the tax issue, the donor has all the power. So if you're the donor.
So I'm the donor. How do I get the court administrator to reverse all of this nonsense that's gone on henceforth?
Let me read the.
I mean, think about this. It's already gone for sale. There's been no true money or anything transferred, and I have listened and taken notes on all this stuff.
But listen to this. It's Section 318 of the Restatement of Property defines power of appointment as a power created or reserved by a person, the donor, having property subject to his disposition, enabling the donee of the power to designate, within such limits as the donor may prescribe, the transferees of the property or the shares in which it will be received. Section 318 specifically excludes from the definition of power of appointment the power to evade principal for the benefit of the income beneficiary, whether it is exercised directly by a holder or by a trustee. The power to revoke a trust and the power to allocate income among a class of beneficiaries, whether it is exercised in a fiduciary or an individual capacity. The regulations under Section 2041 and 2514 of the Code state that for tax purposes, the term the power of appointment includes both the power of evasion and the power of reallocation, the power to alter, amend, or revoke the instrument creating the property. There's your power right there.
Now, I didn't hear the initial citing of where that came from.
This came out of, this is one of the documents I gave out last Tuesday. This is Volume 52, Tennessee Law Review. See, nobody reads stuff like this.
No,
the power of evasion, the power of to alter, amend, or revoke the instrument creating the power, which includes the deed of trust. Isn't the deed of trust the instrument that created the property?
So,
power to remove a trustee and appoint one self-trustee if the trustee has any of those powers. This is in footnote 18 and 19. Let's go down to footnote 18 and 19 so see what that says. and 19. Where are you? Here it is. Treasury regulation. Restatement of property, section 318, number 2. And then 19 to property at death. Okay, let me I'm going to pull these up and read them to you so that you'll understand why you guys are not, you're giving all your power away. You're not exercising your power. You got all this power, but you don't have it if you don't know it. If you don't know what your rights are, you don't have any.
So you're way beyond all this pre-14th Amendment citizen crap, all this stuff that we're hearing in the, all the nonsense. Are you agreeing that has no bearing on anything?
Yeah, I'm beyond all that.
Okay.
I'm taking the pig down to the ground and cutting its throat.
Okay. By hand. Yeah, I understand that. I've been on this call all night long, and I'm trying to relate with what you're saying based upon my personal issues because I'm in.
Okay, I'm going to read you what this restatement this is restatement 18 number 2. I'm going to read you what this says. Definition of the power of appointment. Now listen to this. This is very revealing. Except as stated in subdivision or subsection 2, a power of appointment, as that term is used in this restatement. You know what restatement is? That's restatement of the law on contracts.
Mm-hmm.
Is a power created or reserved by a person, the donor, having property subject to his disposition, enabling the donee of the power to designate within such limits as the donor may prescribe the transferees of the property or the shares in which it shall be received. The term power of appointment does not include a power of sale, a power of attorney, a power of revocation, to cause a gift of income to be augmented out of principal.
Conference is scheduled to be broken down automatically in
5
minutes. To extend the time by 60 minutes, press star 8.
I can't do that from TalkShoe, so got 5 minutes to wrap it up, Gene.
Okay, you have all this power, and nobody's. You have the power to.
All right. I got where you're going because I've been through the restatement. I've been through that.
Now you know why you have to understand tax law. I understand tax law. When you make them liable for the tax, they're gone. They burn rubber.
Do I make the administrator of court liable for this since it's already gone through so many series?
Yes. Yes.
Okay, I got you.
All right, it's going to close out any minute. I just want to say I love you to everybody, and thank you, Gene, for coming on and spending all this time, and I'm sorry. The rest of you folks, there's 8 people in line. I'm sorry he didn't get to you. Go ahead and talk until we're cut off, Gene. I love you, everybody. See you on Tuesday night on Gene's call.
Yeah.
So,
I love you too.
And Merry Christmas to everybody, huh?
Yes.
So how would I present this letter to the administrator of courts? As myself? As how would I present this?
Tell them you're the zoner under Title 26, Section 2038, 2041, and 2514. And you're appointing him as the appointing him as a trustee. Make him liable for taxes.
So under a power of appointment, then because it has to go to the administrator because it's already been denied an appeal. So I guess the trustee's the only answer to go.
Yeah.
Okay. All right. I'll see you Tuesday.
Okay.
Okay. Let's see if we can take one more. Go ahead, Oregon. Quickly.
Gene, how do we spell?
Go ahead, Oregon.
How do we
Go ahead, Oregon.
Toby, how do we get hold of Toby if we don't have Skype?
I don't know. Gene, how do they get a hold of Toby if they don't have Skype?
You got to download Skype. You got a computer?
No, I got to get somebody. This is Fritz. Please give me a call about Schweitzer.
Okay, have I got your number?
Yeah, he gave it to you earlier.
Okay. Okay.
All right.
I'll give you a call.
Okay, let's see. Let's try one more real quick. Idaho. Go ahead, Idaho.
Is that me?
Yep, go ahead.
Oh, okay. Are you Angela?
Fine, thank you. I'm afraid we're going to get it cut off real quick, though, if you had a question.
Okay, Jim, how are you? I have some question. Would you please help me out?
Make it quick.
The first one is we have a property is free and clear, paid off already, but the county assessor raised the property tax way high, from about 4,000 to 15,000, 3-4 times higher. So are there any way to stop their robbery activity?
Yes. Can you get into the Tuesday night class?
My computer has a heart attack. this week about all the different, all the